Hey, chat. Guys, how are you doing? Sorry, God, StreamYard, like, you tell it to go live and it just sits there. It wasn't loading, so I am sorry about that. Anyways, welcome. We are doing day one of Sarah Boone. I mean, there's not much to say about chat. It's Sarah Boone. We've been waiting for this for, it feels like years, and I mean, it has been years. And I just realized the thumbnail never loaded. That's great. Anyways, guys, it's Sarah Boone. You know where you love her. If you guys are new, welcome. My name's Sean, also known as Potentially Criminal. I am a defense attorney in the Cleveland, Ohio area, and we are going to watch day one of the Sarah Boone trial. Now, if you guys don't know Sarah Boone's story, back in February 2020, she and her boyfriend, Jorge Torres, were drinking, and at some point, it's not really clear what happened. He ended up in a suitcase. They were playing a game, playing hide and seek. I don't really know. At some point, he's in a suitcase, and he's a really small guy. Sarah, at the time, was they're both little people. And I don't mean like midgets, but they're smaller people. At that point, he's in a suitcase, and then he's like, help, I can't get out. Please help me, I can't breathe. He's suffering positional asphyxia. Sarah then starts filming because she had been drinking, and it's like, well, fuck you, that's what you get. And she taunts him. And we see a clip of a video like that. And then we see another video where he's like poking the suitcase, trying to get out because he's dying. At some point, Sarah passes out, wakes up in the morning, and is like, oh my God, he's dead. I'm not going to reveal all the details, but a lot of funny business happens. And ultimately, Sarah gets charged with second-degree murder. There's a lot more to the story, and we'll get to it. But that's where we are. This was in February 2020. It's almost been 5 years now. Sarah's gone through 8 different attorneys. 4 of them were not her fault, but she's gone through 8 different attorneys. She represented herself pro se for a while. And now she's got a team of 3 attorneys who are representing her, and they kind of parachuted in right at the end of August. And they've basically prepared a trial on like 30 days notice. So that's kind of the long and the short of Sarah Boone. It's been the long and the short there. Sarah did receive a plea offer. They offered her 15 years. It would have been for manslaughter. And as it being manslaughter, she would have only done, under Florida's laws, she was only going to face 65% of that sentence if she did good time and applied for everything and didn't cause problems. So instead of 15 years, she would have done just under 9 years. And she's got about 4 years down. Well, guess what that means? She's only got 5 more to go. And still she's like, no, don't want it. Don't want it, so we're not going to do it. So we are going to get started. We got day one. They started it yesterday. I know some people will watch it, but I know not everyone did. Sarah's also stupid. Yes, Sarah is very Dunning-Kruger. She thinks she's the smartest person in the room. She's clearly not. And I think we're going to see a lot more. A lot more of that. Now, guys, the audio does suck, but I do want to say we are going to be blessed with somebody did some work in the meantime. And that person has kind of revamped the audio. It's somebody we've dealt with before and listened to their stuff before. We talked about them before on the show, and I consider him a friend of the show. I haven't heard from him in a while, but it's through Veilhammer Media. If you guys know Veilhammer, he's a really good audio wizard with these things. He redid the audio for the opening arguments, which really sucked. And if you guys can, he remasters audio for all kinds of things like the Jodi Arias trial, all that. He's only got 696 subs. Guys, if you could show him some love. Show him some love there over at Veilhammer Media. This guy deserves to be over 1,000. But let's get him over 700 tonight. He definitely needs it. If you guys can help him, I'll suck your audio right out of your ears. Well, thank you. I appreciate that. But yeah, guys, give Veilhammer a like and give him a subscribe. I know he would appreciate it. And I don't know if he's watching tonight, but it'd be a nice surprise for him. And Thank you guys. I appreciate that because yeah, he does all this work. You know, if you feel like you want to do that too, you can hit him up. He's got a Cash App at Vealhammer. But anyways, we're going to listen to Sarah Boone's opening arguments because the opening arguments are absolute hot garbage, audio-wise, for some reason. And I guess they get fixed in the meantime, but we are going to watch those, and I just wanted you guys to understand that as we get going. Yes, at youtube.com/VealhammerMedia. So, what says free Sarah? Well, oh, by the way, guys, I forgot to mention, Sarah is going to try to argue the battered spouse defense as a reason to justify why she did what she did to George. It's probably not going to work. And guys, I'm going to tell you right now, Sarah's going to go to prison. There's no way around it. She's facing second-degree murder charges. She faces a minimum of 22 and a half years in prison. I think it's a mandatory minimum too. So yeah, there's a lot riding on the line here. A lot riding on the line. So we are going to go ahead and start here. Oh, he's over 700 now. Awesome. I appreciate you guys taking care of him like that. So good job. On the jury. I did not know that, but ooh. Yeah, well, hopefully her attorneys had an idea of what they're doing because I don't know. So let's get started. Alrighty, here we go. Why is this not out of the way there? Gandalf the Great says, I bet she smells funny. Oh, yeah. And also, guys, Sarah did get her right to wear fancy clothes. She did not get her right to have a snacks brought with her. So she doesn't get her cookies and punch and pie. She gets none of that, so she's on her own. Her tummy's going to rumble. But here we go. Here we go. Let's go. I like the oh, cool. That's pretty neat. There she is, chat. America's sweetheart, Sarah Boone, walking up to the media table. You know her. You love her. Here we go. Haven Cakes, we're going to watch all day one, but remember, we're going to watch all day one. Remember, we're going to watch it at a little bit faster pace, and we also get to skip all the breaks. So there's some advantages here. Don't fret. We normally go about 1.3 times speed because it's amazing how fast or how slow people talk. So here we go. And also, we have all this dead time.
I'm ready.
William Chase, the state.
James Owens on behalf of Sarah Boone.
Tony Henderson.
Ooh. Wow, Vealhammer, you did a good job. I turn it down a hair.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at council table wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them deal with just billings, observations by the medical personnel from it necessarily apply to the issue of anxiety, as the board indicated. I did include certain pages that discuss depression issues because I believe that they were not anxiety related, maybe the cases.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Too
Apparently,
fast
these
audio.
are all
All right, I'll
just
slow it down.
related to a January
I'll slow it down.
23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records
I'm going to slow it down, chat. Let me know if this is too fast.
from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first two that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those two pages. Pages 21, and then they skip 22. 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there is a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because...
Okay, guys, so right now they are doing a pretrial issue. Richardson, there are some issues about admissibility, some exhibits. And the prosecutor's saying the defense wants to exclude things that will cause basic foundational issues going forward. So the prosecutor saying, like, no, the defense has it wrong.
In her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested. Shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49. to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63. It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically, we're asking for pages 26 and 48 to be included.
Okay, thank you. The the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 7th 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records.
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue.
So there's an issue about records that Sarah sent, and the issue with discovery is, well, if you didn't send them early enough, how do we have a right to view them? And if we don't have time to prepare, they should be excluded. Sarah's attorneys are arguing we did send them. We sent them a while back. I'm not sure why it didn't happen. Also, somebody's asking what's in the box. Come on, guys. You know what's in that box. You know what's in that box. We all know. What do you think's in a box like that? Oh, that's why it's not working.
Until late, it was yesterday or the day before, that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay. And when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay. My understanding, that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may real quickly, based on the invoice that was sent from the Advanced Billing Department, it's a subcontractor, the request that they have September, I suspect they waited until they received confirmation payment of $135 for receipt of that, so we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and I think there were issues as to the matter of people. I did speak with the state yesterday after you had that session of the matter of relationship to, and was told that that already passed both records. I don't think that was in reference to the state submission.
Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, like the stack of documents.
Is that the 119 pages, sir?
No, sir. It's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
They're coming in, chat. Here we go. Well, now we're getting to it. It's time. It sounds like we're ready. Here we go.
There was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed.
Ooh. Ooh. Chat. Shut your cell phone off. Judge Kranick is not fucking around. Oh boy. Oh boy. Oh boy. Uh-oh.
Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was entered as one, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that. And I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion. And that's part of why I had to raise this issue was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading on it. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide information.
Okay. I appreciate y'all working together on that. So here's what we're going to do.
If I may,
Yes.
we had told the state that we would bring in a printed copy, not the PDF.
And guys, this isn't uncommon, like a little bit of like, this one isn't like, oh my God, they're either side's pointing at each other and you're screwing me. No, you're screwing me. No. This just seems like a little bit of a logistical issue. That's not uncommon on the eve of trial either. Happens all the time. All the time. It's not Sarah Boone. It's not her attorneys. This happens all the time.
This morning, but Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they were able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I've seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that.
So real quick, how did this judge do on that so far? That is a fair thing. And the defense did a really good job. We fucked up. We didn't get things out right away. But what did we do? They immediately tried to condense what they were arguing about. They cooperated with the state. They were open about it. They said, hey, here's what we're looking at. Here's what we want to show. It gave the state a chance. They also were providing the state. I know somebody there was just saying, is it a kind of like bullshit to ask for a PDF? Well, if you've caused the problem, it helps to show, look, I'm going out of my way to fix the problem. I'll give you an easily searchable electronic document, which makes it even quicker for you to do your thing. So no, it's actually a good idea. They're going out of their way to make this not a problem. They're trying to make the judge okay with it. So no, this is exactly what you should do in this type of situation. Kimbo says, can you put money on Sarah's books for me? I forgot my wallet. No. Now, if you guys just heard, the state is saying the defense shouldn't be allowed to use some demonstrative aids. Now, you can use demonstrative aids, but for example, like jury instructions that might not be used, depending on how the trial goes, yeah, that's probably a bit of an issue because it's not necessarily guaranteed to happen. But let's see what other things they're going to show here or they'll talk about.
Could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force.
I'm not discussing the jury instructions at this time.
There are evidence of prior threats, prior events, violence.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did quote up on the justifiable use of non-deadly force.
But still, that does not answer my question.
I would agree not to use them.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon considering the verdict. You want me to read it out?
No, I can see it, sir.
And the other one is a reasonable doubt is not a real possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge's opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon.
Okay, that is a horrible argument from the state. We're trying to tell you what's going to happen. That's your problem. That's not mine. That's not Owens' problem. Sarah Boone should be allowed to make an argument there. I do agree you're arguing the law right now is probably not the best. I do think reminding people of their burden of proof, I don't think is a problem, and I think that that's okay. But really getting the jury instructions, yeah, because you don't know how it's going to play out. I just think that's he's gonna smack Owens here. They're gonna get spanked. I know that. But you did bring up, who was it here? Yeah, Anna Wall says, why are you making your closing as your opening? Well, I mean, yeah, I mean, sometimes you got to work with what you got here. They don't really have a strong case, but it also helps. You don't have an like they don't, it's not their job to really wow and do all that. It's the prosecutor's job in the opening. So, anyways, let's see where we go. Yeah, I don't like this prosecutor either.
We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory. And I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone. The arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from.
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them. And and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, that in many ways, we do it where we give them the law at the very end, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
What's up, guys? Yeah, so the judge is reviewing, so he's going to review these things that are set for the opening argument. I don't know what's going to go on with these, but I think he's going to shoot them all down. Just my guess. Also, what's up, man? Philip Tapp, hello, how are you doing? Go ahead and entertain us. Well, I'm going to skip ahead here. Hold on.
Identified is A, defendant exhibit A. Sheriff Boone was taken by law enforcement on one of the incidents involving arrest. Whatever here, which we believe is relevant.
Guys, the judge is reviewing them right now, so that's why we're not hearing anything.
With 6 or 7 holes in it of where George Torres hit the TV in the back, right there. That's exhibit E is a blow of injuries to Sarah Boone's left arm from George Torres. Exhibit F is a close-up of the wound Sarah Boone's leg, where
I would agree a lot of this is probably Sarah's idea, or she asked for it.
George Torres stabbed her in the second. Exhibit G is a close-up of Sarah Boone's face, which shows where George Torres poked her with a curtain rod. Exhibit H is a photograph close up of Sarah Boone after she was kicked in the head by George Miller. Lift it to the eye. Here's another close up of Sarah Boone's face after she suffered injury at the hands of George Miller. All these, I believe, Judge, all these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. The state had the photograph. The state provided the defense in discovering the photograph. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the both-sides pages of the photograph, and then using these as the most to show the jury their opening and then closing the injuries that Sarah Boone sustained at the hands of George Miller.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement, Mr. Owens?
Yes, Sir Judge, I sent you some cases.
When did you send it, sir?
This board.
I have not received it.
I think Judge, we're already on board, so we sent to the court and Virginia.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. Separate one, but I'll check.
Okay, guys, they're trying to kind of get some pictures in to kind of taint the jury a little bit and kind of prime them for their theories. Also, what am I eating? I'm eating a Cuban torta. So it's very spicy. No, Christine, we haven't even started yet, actually. We're still at opening arguments. Don't worry. We haven't gotten anywhere. We have not even started. So don't worry. Don't worry. We got a long way to go here.
Willoughby State 259, 7th, 3rd, 23.
Here we go.
Florida Supreme Court 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements.
I don't think you're going to.
Alcaguer case, which is the 2021 case. Supreme Court, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that was in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit in that case. It was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound, advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm.
Real quick, Poe, you asked a question. Is there a rundown? Basically, Sarah somehow got her boyfriend into a suitcase. He was a smaller man, so he contorted himself into a suitcase. She sealed it up, and he suffocated inside of it, and she didn't let him out. So that's why That's why she's being charged with murder. There's a little bit of a description. If you click down below, it'll tell you a little more. But that's kind of like the 10-second view.
I think the two instructions would read, by the Sarah Boone, who because of prior threats or difficulties with George Torres had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone are those of a reasonable person. As on to violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use unlawful.
I don't think the judge is buying it.
Belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes.
Yes, sir.
Judge, the standard is it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, and certainly this is A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well.
So it's interesting from the state. They're like, look, we're going to show all kinds of gruesome crap. We're just not doing it now. Normally, they jump all over the chance to do things like this. So I'm surprised they're being very reserved.
There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I, state is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. if we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive.
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great, blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that?
No, what I ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'll talk about self-defense.
I understand.
And prior difficulties, prior acts of violence, the standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my clients, we believe there's going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that.
Understood. Your response to Exhibit B.
Look at the, which one's B?
It's her on the back porch with the two dogs.
Judge, not only did he abuse, North Shore is abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want introduced, that they listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, George Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
They're checking, Judge.
All right.
On one of the things.
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You can talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was.
Okay, guys. So we knew the judge wasn't going to let him do the jury instruction. That was kind of obvious. The issue here was showing Sarah all beat up and showing what George did to her. Until Sarah shows self-defense, she can't introduce evidence about George's character, that he's a bad guy or he's a big piece of shit. And the idea is they could show these pictures and then never bring it up. And now the jury's got, oh my God, those pictures of Sarah getting her ass kicked by George. And it allows them to assert self-defense without Sarah having to testify. So that's what the prosecution's arguing about. And I don't think that's unfair, because the only way those would come in, like if you're not introducing those as exhibits, I don't think they should be introduced like that. So normally the state crying, I don't care, but that actually makes sense. So I don't think that's a bad ruling either. Pretty good overall from Judge Kranick, unlike a lot of his other rulings.
Is a victim. You could talk about some incidences made happen, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense. All right. Are we prepared to bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
Same. We intend to play the 2-minute suitcase video to the jury in opening statement.
State?
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach the bench.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose, it's good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
All right, Chad, here we go. Here comes the jury.
Here, Henry.
Here comes the jury. I'm excited. If the judge starts reading through jury instructions, I'm going to skip ahead through those because we don't need to hear them. Nobody cares. Let's get to them doing the thing.
Defense, do you recognize our jury?
Yeah.
Can the parties approach for a moment?
The hell you need them approach for now?
Instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. And then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you approach for a moment? And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
Now, here's the thing. Owens probably, guys, you know, like, who knows who's already in the elevator? Who really knows? I mean, there's probably a million, like, who knows really what happened there? But yeah, it's not a big deal, but it has to be clarified. So Owens isn't in trouble. Those jurors aren't in trouble.
It's just to be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way? Did it have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. Evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. Now, for conscious disregard for whether he lived or died, you will see and hear the video. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground face down with the zippers facing the floor. you will hear, Sarah. The defendant will say, for everything you've done to me. Sarah. For everything you've done to me. Sarah. Fuck you. And then the defendant laughs. Sarah. Fuck you. And the defendant laughs. Sarah. Stupid. Sarah. That's my name. Don't wear it out. Sarah. I can't fucking breathe, baby. Seriously. Yeah. That's what you do when you choke me. Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show because of the intoxication from alcohol is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds after he's been in the suitcase since at least 11:12 p.m. is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres is put into this suitcase and left it down? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Torres, and eventually realizes, oh my gosh. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. Someone she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. The next thing she does is she doesn't call 911. She calls Brian Boone. Brian Boone. Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, they'll co-parent. And that weekend included Friday, Saturday, Sunday. So they got 3 scheduled. And then Mondays and Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Barnes' responsibility. So February 23rd, 2020 was a Sunday. Now he's led into Monday. Mr. Boone had been trying actually to contact the defendant several times that morning. He just wanted to confirm she was going to get their child after school every day. And there had been a history of reliability on that issue. So you can see in the phone record, he calls her, and then she finally calls her back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, 10 minutes. And then she's explaining to him what the heck is going on. He peeks into the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right. There's a doorway that you can see all the way through. And on the back side of the kitchen in the front area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check, please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside, though. being the good partner that has been. So now, after having first called her ex-husband, after having first waited for Ryan Boone to come over, the defendant makes the 911 call.
If this plays out like that, oof, 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 oof.
What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold. He's stiff. He's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies, his death was taken to the United States doctor's office. What the doctor found was what you expect after being left in the suitcase, about the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breath when you're crumpled up like this working, and environmental suffocation. You don't have to have a plastic bag over your head, take a shot with a full roll of duct tape, seal it off 100%, and be worthy of the vacuum of space to environmentally suffocate. It's close enough. You can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, some kind of blunt force trauma, torso, in space, mouth. She'll use words like confusion, will help her explain confusions and bruises. She'll use words like hematomas, will help her understand for you all that that means bleeding under the skin and blood, what you expect will prove that's why they're in. But it had all this additional trauma. It had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up. The defendant interacts with the first patrol officer. You will see and hear that body worn camera. It's more of the same of what we heard on the 911 call. I see. It's good. I fell asleep. What happened? A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found at a suitcase of Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were just literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is one bottle of wine and plus a fraction of a bottle of wine left over from the night before.
Now, real quick, guys, I know some of you are saying, oh, wow, this prosecution argument sucks. Prosecutors usually don't give very phenomenal openings because they got to lay out so much information. But it's going along. It's at a decent clip. It's not bad. It's not aimless. But it's far from the best. But remember, prosecutors don't usually do a good job at these, but they don't have to. They could suck at these and it's okay.
Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are $7.50 milliliters.
Okay, now you're running into the weeds here, buddy. I don't get this, but okay.
About that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters. So the equivalent of 2 standard bottles of wine.
Yeah,
A 1.5 liter bottle of
Stay there.
wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before.
They were mega pints like Johnny Depp. Oh my God, we can't get away from that trial. Oh.
Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down. And that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out. We're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps, stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean Orange County Sheriff's Office, in part with her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped them over. I flipped them over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the two videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo, sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres, referring to Mr. Torres, getting rid of. That's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, are all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. The door, we shall not.
Guys, I'm sorry, we can't hear anything.
Halloween in like 13 days. Part of the vampire lore is vampire can't come get you in your house. Well, participate during this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years. And as we come inside this room, at her beckoning, we're going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she ever been punched. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 3.42 once when he got treated at the hospital. This is a man who had serious alcohol problems, and I expect you're going to hear about it.
342 is really high. Holy cow.
Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these dates are at bars, and there's nothing wrong with that. But, and just typically.
Guys, once we get through the opening arguments, this is the best media we have, the audio we have. We'll switch over to closed captioning on probably Long Crime in a minute. But Feelhammer's the only guy that did the better job of salvaging the audio the best we could. So I apologize. There's nothing I can do about that, which kind of stinks. I'm not kind of stinks. It really stinks because we can't hear him, but you guys know what I mean.
Ends up, she's going to tell you, I suspect, or you're going to hear that she said one way or another. It's one thing or the other. Like I ask a dude for a cigarette, Forrest looks out, and I'm going to pay the price. Just things like that. You're going to hear, potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing. Black eye, cuts in the face, perhaps from the Kirk garage incident that was mentioned in the police interview happened about a month ago. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting, playing around. But nonetheless, I suspect you're going to hear and see a lot about their past injury. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take the lead of the tour in this room labeled the defendant and the victim's past history. I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 20th. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. Well recognized, the experts will tell you.
Okay, chat. Is that a bare, like, is it barefoot? Or is she wearing some slides that are like very, very beige? I don't know. She's also the court reporter. She can kind of do whatever the hell she wants because she's never getting up. So just, I don't know, guys. I'll answer the question. I don't know. She's
All that. Not disputing that at all. But there's some things
What?
that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5. Diagnostic Statistical Manual, version 5. And it's text revision, something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it needs these three.
yes, all you pederasts. Let us know.
Some have to be prevalent for a certain amount of time, so on and so forth. You have it, it's a cookbook. You should rest it for that. But because it's not in the cookbook, you may get some disagreement about what it means between experts. It's kind of like grandma's recipe and down from generation to generation. But what I expect you'll hear is, now it's important for people who don't have experience in certain abusive relationships that are violent to understand
Mm.
control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You'll hear about all this. And what it ties into at the end of the day, we talked about this during jury selection, is if there is a self-defense.
And chat, I'll be right back.
This is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society. Years ago, when this is first being researched, the question would be, well, why don't you leave? Battered Spouse Syndrome, the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances maybe would actually if you get a self-defense. That's what it's used for. It's not used for explaining subjective beliefs at one point. What we will also hear about these things is just like any other doctor or any expert, a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. I created this. You're not going to take that home inspector's report. Let's say, lift the hood, take the tires, do all the things at the box. Here, the car has that. You want an expert to get reliable information. The expert's opinion is only as good as the information that he or she wants. They would say, yeah, you gotta take into account credibility of the person who's giving the story. Even if it's the patient, the client that is saying all these things have been confirmed. You gotta find proper information. You gotta check reliability, particularly circumstances that we discussed. Another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that it's not something that applies. Some people can go home and fight like cats and dogs. That's just their day, and they get over it. They live their life, fight another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this is testimony from the I expected Dr. Harper said it applies to Boone. But we'll talk to her about what she relied upon to make that conclusion. We'll talk about some other things, take that journey together. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, statements that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided to deserve it. Not because the evidence will show an objective, reasonable person in her circumstances. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule sequestration will be invoked. Thank you. You may proceed, sir.
Ladies and gentlemen, good morning. Appreciate y'all being here. I'll introduce before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Bell. Now, this is going to be several days long. Obviously, today, we're not sure, but trying to make arrangements for witnesses upon expert witnesses. We'll know more probably within the day. I know your focus is on this case because you took notes. Ladies and gentlemen, there's no higher call. No higher call. We're going to ask you. find Sarah Boone not guilty. That she was justified. In the force that she used to defend herself. That force was reasonable under the circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggled with the use of alcohol. You can imagine it. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had, and considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side in attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon. And they come out with one of these larger bottles of the wine. And then, of course, there's a receipt. And the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, that's what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone, and George had said, "I want to go get some cigarettes." So there's a convenience store right close by their apartment complex, and Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, got her debit card, and he went over to the Publix and he got another bottle. I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in and going out, and there'll be a receipt for the purchase of that bottle, and then they'll do that bottle. Will be as long as he can, along with the other bottle. Well, when he comes in with the second bottle, Sarah knows this is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. Attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, or she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly and they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they move back and forth. Well, she comes down the steps. She sees him getting in and settling in the suitcase. So she walks over there and, they see each other. They smile and laugh. And she zips him up. And she zips him up and they laugh for a while. And they carry on. She sits on the couch. And at some point, he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get her. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zipper's off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from George Torres, which the law acknowledges that every one of us has the right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you, why that happened, what were the circumstances surrounding that.
Chat, sorry, I had to step away for a second. I had to go pay the water bill. And then 2.0 is showing me why it's not a sock. Well, it's a sock. It's like a footy sock, she thinks. Not a shoe. Either way, guys, I apologize. I had to step away. But, God, this is not a good. This defense is bogging down. It sounds like a prosecution argument. There's way too much in it. This isn't grabbing my attention. I don't know about you guys.
Involving that. Her son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loved George. You know, you're going to hear why women don't leave. Why women don't
The
leave.
Indians game have been a lot of fun.
And you're going to hear about Sarah
That's a lot of
and
fun,
her struggles, her mental health struggles. Sarah had no intent to kill. The prosecutor mentioned she wanted him to die. Farthest from the truth. She loved him. She hated the abuse.
Pretty true, Aaron.
She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. Thought he was on the computer looking for a job. She looked outside, like he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out.
We'll kind of
He's
talk
total.
about that in a second, Eric. Kind
Tries her
of.
best to do some
Kind of.
CPR. She freaks out. The only family she's got is her ex-husband. Really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And their son is there. Lucas. It's the only thing she knows to do. She's kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian, look, what do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute. Detective Rodriguez arrives. They got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Debbie Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take out all the data, all your phone calls, text messages, photographs, videos, all of it. And they find these two videos. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Costa. Chelsea Costa. And they end up, Deputy Costa was pregnant, or Detective Costa was pregnant. So they end up, hey, we're not going to bring your phone. I'm not feeling good. Pregnant, can you come to the sheriff's department? Which Sarah Boone was telling me that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videos. And so there's approximately a 2-hour interrogation that was on the 25th afternoon when she got there to get her phone. They said, well, we got to come up here. We need to talk. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. It doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there. Who advised her? No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking a stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about cooperative evidence, other evidence that's consistent with the testimony that Sarah Boone did. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense, nonetheless. Now, as I said, the struggles that occurred, many of them involve the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress. You know, we're here today, full packed courtroom. Judge Grant here, but you're the most important people. Because you've got to decide this case honestly,
This is
fairly,
bad.
and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judge it, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in open or in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of that. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. We're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment?
All right, chat. So what do you guys think? Like, that was fucking hot garbage. That was absolutely garbage. Wow. 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 I mean, this was just awful. This was just oof. So we got some things to catch up on here real quick. So we're gonna get to these. iSpread actually had a question from right at the beginning. If she was diabetic, could they, like a type 1 diabetic? Yeah, they would have to accommodate her and have to make sure she wasn't suffering sugar issues. So yeah, I could see that happening, but she's not a diabetic. So Sarah Boone's 13th lawyer says Sarah in chains is so hot. Yeah. Tyler Durden says she should have hired Nick Ricada. I hear he has a snack tray. I didn't even make that joke today. That's on you. Thank you, Tyler. And yes, while the prosecutor's talking, Sarah absent-mindedly begins to shove him in the suitcase. Bifron says, my cat would franchise that box. It's a big cat trap. And Davel saying, but I think showing the accused a photo of deceased of a murder victim in an opening argument is an ethics violation. Is that what you're saying? Like, as an ethics issue? Nah, I mean, there's times where you can present evidence and present demonstrative aid. Sometimes it happens at a thing. It's not really an ethics issue. It's just a fairness and prejudicial effect issue. Poe was saying, given the rundown of the story, I already did that. Examoon's a new member. Thank you, Examoon. Thanks for the support. And then Examoon saying, Sarah Boone exercised a demonic piece of luggage. Yes, thank you. Thank you for one Toonie. Christine Micro. Thank you very, very much for your support and your generosity here with 5 subs. Thank you, Christine, very much. And then Palmyra Productions, he's like, I'll meet you on that one. And he throws in for 5 subs. Thank you very much as well. Lisa says, been a member for 3 months. Thank you for your support. Says, awesome channel, Sean. Love your commentary. Well, thank you. And Devel saying, I have to admit, though I don't like lesbians, that I'm queer as a kite. How kites aren't... How queer are kites? I mean, kites are fun. Skeeve Man for 10 pounds sterling. Not the King Sterling, because he's Scottish, and I don't love the King. I was here. I left a like, and now I'm going to bed. But I'm having trouble with my gallbladder lately, and I'll be getting it removed at some point soon. I'll watch this tomorrow when I can stay awake. Well, I hope you feel better. Sleep well, man. And, yeah, hope they suck it out of you soon. Anyways, enjoy the show tomorrow. Mark Tryon says, in the intoxication is the famous defense best used in DUI cases. Judge, I didn't mean to drive drunk. I was intoxicated. It robbed me of my better judgment. Yes, but voluntary intoxication is not a valid defense. If you voluntarily intoxicate yourself, that's not acceptable. If you were subject to involuntary intoxication, like somebody spiked your drink or something like that, that would be a valid excuse because you didn't realize it was happening. And then Stacy says, I could have bet the Indians game tonight. Yeah, but you got to get out and drive around and pay for parking and do all that. Like, I don't really. Yeah. I kind of don't think they're going to win tonight anyway. So, and it'll probably be over tonight. But thank you for being a member for 10 months. And Garfield says, if Nick takes his case to trial and it's televised, do you think it'll be bigger than Depp and Rittenhouse in the Law 2 community and coverage? I mean, it won't be bigger than Rittenhouse or Johnny Depp. I mean, yeah, it'll be a big deal for us, but we're not going to get like Emily Baker's not going to be sitting there with like 30,000 people watching it. I mean, it's not going to be like that type of thing. But yes, it'll be big for our little sector of the internet. And Eric's saying, is this a self-defense case? Kind of. She's basically going to have to argue she thought he was going to get out and beat her and attack her. So she struck him with a bat, and all of that was triggered by her battered spouse syndrome issue that she had basically had PTSD from all the other times. So she acted out, smacked him, and kind of defended herself. And it wasn't intended to be lethal force, but it ended up killing him. But she had a valid justification to use the force. Is kind of their argument. You're probably thinking, that's not really a good self-defense argument. And you're not wrong. But that's all she has. That's all she has. Aaron, real quick, says it's stupid to claim who is not in hell. It's so ignorant. Part of their argument's going to be George needed killing. Sometimes you make the argument he needed to die. Man needed killing is a defense at times. That they deserved what they got. They got what they deserved. It happens. Michael is saying, for 15 Malaysian ringgit, saying if I restrained a guy at a bar who took a swing at me, then just kept him tied up all night long while not calling the police, that's not self-defense. I don't disagree with you. That's going to be a very problematic issue for Sarah. Malcolm says, my eyes started to glaze over. I wasn't sure what his point was at times. Yeah, I mean, that's the thing, because when you're doing defense, you don't like your opening is probably not usually going to be as long as the prosecution. I think if you're doing that, you're doing something wrong. You should be really taking up your time at the back end on closing. So, I don't disagree with you, Malcolm. Amateur Iconoclast gifted 5 subs. Thank you. And Cat, not Williams. Not that Cat Williams. Gifted 5 subs. Thank you, Cat. And then Snackless Sarah has been a member for 3 months. I know she's not getting her snacks. No punchy pie. And then Chinny has been a member for 6 months saying, can kidnappers now claim self-defense? There's going to be times where they're going to try it. Yeah. I mean, you run the arguments that might, if that's all you got, that's all you got. So, yeah, I understand it happening. Yeah. So yeah, keep an open mind. Some of my lies might be plausible. Well, sometimes that's all you got. Like you guys laugh, but sometimes shit happens. Shit happens in the world. you know, we don't have to be. I would just say, you know, it's the world that you live in. It's the world that we have to deal with. Okay. Brad says, I'm sorry, that was better than Jay's opening. I'm not saying it wasn't like horrible, but I just don't think it was very good. Remember, the prosecutor can kind of screw up his closing. He could phone it in. As the defense attorney, you can't. Also, chat 2.0, real quick. She wants to bring this up. She was doing some research here, and she has been looking at the feet. So there's the foot. And by looking at this foot, you could clearly see there's like a two-tone color. And below that line, like there's a color delineation. So there is a bit of a color issue there. And she says, you know, this is a little bit better of a view. And you could see that there's like this, well, she says you could kind of see something right there like this, which if you look at here, it looks like there's a point on it. Well, what does that mean? Well, she thinks it's like some sort of like socks. What? Yeah, you can kind of see the toes a little bit. So she thinks she's wearing some sort of like little footy sock that fits in, or like a little thin sock that goes over when she's wearing the flats. But she, you know, that's her idea. That's her thought. Yeah. Although this is also a possibility too. And I think this is, you know, this one, it looks like her toes have moved. So she might be barefoot. So for those of you guys who goon to that, there you go. Yeah, nude slip-on, sock liners, yeah. Well, a lot of you guys were asking. So anyways, we're gonna move on from here. Guys, Vielhammer Media did a great job with that. We are going to switch over to Long Crime just because they've got closed captioning. So we're going to do that. Oh, 2.0, everybody thinks you did a great job, babe. So we're going to switch over and go from here. I'm now catering to the fetishists. Hey, dude, I gotta do it. Grifting is grifting, homie. Grifting is grifting. All right. So now we're on to Long Crime. They've got closed captioning, which I think is actually going to be very important. And we're going to get started here, chat. So here we go. And I got the sound all the way up. So you guys might need to adjust a little bit. Also, I got to use this fancy overlay, and I didn't want to put it on that stuff Vielhammer worked so hard to create. All right. Let's move along here.
State, you may.
Oh, there we go.
State, you may call your first witness.
State, we call Juan Torres.
Is my mic okay now? You guys said I got muffled. Am I better now?
Mr. Torres, for bringing in this morning, please, you swear will talk the testimony you should give, shall be the truth, the whole truth, and nothing but the truth, so help you God.
Circuit Morning, you could be seated. And once seated, if you would state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And How many siblings do you have?
Six or so.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, I would say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Pretty close.
Would you see him pretty often?
I would try not to go over there too much.
Who was George living with at the time that he passed away?
Wait, Sarah?
And without getting into many details, what was your relationship like with Sarah?
We wouldn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
You recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it. We just,
Did she sound upset?
she sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
All right, Chow, fix the captions. Hold on. I didn't realize you guys couldn't see them.
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother, Jorge Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, not you, but any of your other siblings?
No.
All right, sir. Let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called to?
He called me.
and then y'all were talking. Is that correct?
So,
Yes, Eric, I agree, man. Okay, listen, dude. Why, like, these are like staff attorneys or like law clerks. Like, they got chairs. This is just like, you could tell the guy's sitting, but like, it makes him look like he's making him do like wall sits or something. I do think it's kind of cool. He is like, hey guys, you're gonna be in here. He's probably like, you guys want to see a trial? Cool. But also, I think he needs them right there in case something happens and they have to go do some research or whatever. They've heard the issue firsthand. I just don't know why he doesn't have him sitting in the fucking gallery. This just seems really awkward. Like he's got the Council of Elders of the Orange County. They're there. It's just like Hot Fuzz. They're like, they got the Elders Council. It is just weird. Well, anyways, hold on here. We're gonna keep going.
Visitor.
Well, we also,
Visitor for you.
I know you guys have not seen him in a while. We got a Clyde sighting. So there you guys go. If you haven't seen Clyde in a little while, he is alive. The Haitians did not get him. So anyways, here we go.
And when he called
Yeah.
you, did you notice anything about his speech or his voice?
Yeah. Well, I know there is law students,
No, he's
but make
fine.
him sit in the gallery. It
Sounded
just looks
normal?
weird.
yes, sir.
Okay, so he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about,
Oh my God.
did you
he's
tell
so-
at that time if he had been consuming alcohol?
No. Because I knew when he would drink.
Okay, so in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah,
Yes, sir.
is that correct? How did you know it was Sarah?
Like, guys, I understand that they're law students and all that, or law clerks or somebody. I just think they look really goofy all up there. It's just like, have them sit in the back or something. Like, he could clear out space somewhere. I just think they're kind of goofy up there.
I can tell in her voice.
You recognized her voice, so you could hear her, is that correct?
Yes.
All right, and you've heard Sarah speak before that time, is that correct?
Yes.
And you've heard her speak on the phone before that time, is that correct?
Down, Baba.
And you said that Sarah was yelling, is that correct, sir? And she was yelling about, he's choking me, or tell him about choking me,
Yes.
okay? During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
You're a good boy, Baba. You're a goodish boy. I love you.
Not really.
I'm so happy we found you one day.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No?
Went down?
Sir, at some point, your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can.
You may, sir.
Yeah, I don't
other
really
than,
know what that got them. That just seemed weird.
Siblings. Your mother and father, do they live in this area?
Yes.
Were there times that
Jesus,
George
Joe,
would stay with you?
damn.
Yes, sir.
The fire.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
This witness be released.
Yes, Your Honor.
Defense?
Actually, we'll keep them subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You release subject to recall by either party. Thank you.
State would call Devin Jamro.
All right, chat. Devin Jamro. Jamro.
Raise your right hand and be sworn. Please, you swear or affirm that testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Sir, good morning. You can take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DEVINJAMRO.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Publix Supermarkets.
And what is your position with Publix Supermarkets?
I am the assistant store manager.
And at what location?
Currently a Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Guys, Publix is like the big time supermarket chain in Florida. They love Publix down there. Everybody in Florida loves Publix pretty much.
Your Honor, may I approach the witness which has been previously marked for identification as states D and been shown to defense?
D's and Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as states D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, at this time I'd like to move what's previously been marked for identification as states D into evidence.
Any objections?
No objection.
What was pre-marked as states D will be received into evidence without objection as states 1.
Your Honor, may I approach the witness who's been previously marked for identification as states J and shown to defense?
You may.
So I'm showing you it's been marked for identification as states J. Can you take a look at that disc?
Yes.
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did. Yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
and they fairly inaccurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification, the state's J, into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day. State, you may call your next witness.
State will call Joan Williams.
Raise your right hand, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the Orange County Sheriff's Office,
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each
Yes.
call, correct?
Yes.
Your Honor, may I approach the witness, which has been previously marked for identification as states L and been shown to defense?
May.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
What was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Thank you, ma'am. Can the parties approach momentarily?
Okay. So, I mean, guys, that Publix manager doesn't really do anything. That's not really important. You know, they could skip that one. This 911 manager, there's nothing here. You know, 911 dispatcher, they're getting the 911 tape admitted, laying foundation. So here we go. Now we're getting to the real stuff. So, Kim was saying, do you remember when you could get big and tall suits for like $20 on eBay? No, because I wasn't really fat back then, so it wasn't an issue for me. So, just saying. So here we go.
Yeah.
Oh, shoot.
State, you may
I
call your next
forgot.
witness.
State will call Vincent Battaglia.
Raise your right hand, be sworn, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Him.
That's Brandon Motes?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time?
It was
this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like, if I do hear anything, like doodle walls or whatever is out back, just kind of keep my mouth shut, like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on up there?
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Did you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah. All the time, it was like a back and forth. Yeah.
So other than the statements and the phrases of I hate you, you weren't able to discern the the contents of this argument?
No, no.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, you know. Then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment. So it was like, there's like a little kick out next to my patio, and that's like, that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah. Yeah.
I have no further questions.
Any cross-examination?
Mr. Cagley, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Are you aware that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you.
Yeah, yeah.
Just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know from your experience with Sarah Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Hold on.
Yes, sir, of course.
Well, Vincent, I think you would testify, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object as to improper impeachment.
Approach.
Okay, here we go, guys. Here we go.
sir, would it be fair to say on that date you got home around 7?
I don't
7
see what this is going to help
7
them.
p.m.
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the
I don't think you've heard
afternoon.
your
Because I went to
there.
work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you. Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like arguing, I could hear it started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. You guys know.
Okay.
Your Honor, may we approach?
Yes.
Okay.
Great day. Thank you.
The state would call Brandon Moats.
Bless you.
What class is at 1 a.m., honestly? Yeah. I don't know. Other than it's probably like when it got released online. I don't know what that's from, chat.
Are you writing these forms? Swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BRANDON MOATS.
Thank you. Mr. Castro, you may inquire.
Good afternoon, sir. Now,
Good afternoon.
can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you lived, tell us, how would you describe the walls that separated the units?
Yeah, I remember that my bedroom was like the front-facing bedroom, and our walls shared a wall with where their staircase was. So, like the way the apartments were laid out, we had a one-story apartment, they had a two-story apartment. So they had a staircase running right next to the walls, next to like our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin, so if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that would it have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a one-story apartment, and then they next door had like a two-story townhouse, so we only had the one floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me, like it was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate. I remember me and my roommate talking the next day about like we could literally like it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have. Yeah, I never saw her after that happened.
No further questions.
Any cross-examination?
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or George Torres. Is that correct?
Yes, sir.
I think you said you tried to avoid them.
Yeah. I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Okay. Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
Okay. So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
Now, I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was 10 something, initially it was around 7 p.m. You heard arguing?
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home. So I would have gotten home around 5:30, and it would have been after because I came home, I made myself lunch and I took a shower, and then I heard all of their arguing. So it would have been about an hour and a half, 2 hours after I got home. So around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
Honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth. Or if it was
Let me
just
ask you this. Did you hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
Okay. If I can confirm, Judge.
Yes, sir, of course.
So they're trying to establish it was a big old fight, and it was dangerous and scary. And this is helpful. They're trying to establish the big, scary fight. Sarah was in fear because George was crazy. But they're both being loud, I think, is going to be... I think that's a problem here. I mean, it's better if George is only loud, but Sarah being loud isn't fatal, but I think you'd only want George being loud.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall.
All right. All right, sir, you're released subject to recall. Thank you. Can the parties approach?
All right. I will say this is chugging along very quick. I am very surprised at that.
In this very members of our jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse at home, maps.
Yeah.
We'll see.
Blah, blah, blah. Okay. So let's see if there's any more defense stuff.
Thank you.
Let's see if there's anything else, or we'll go ahead and skip lunch.
State, anything we need to address? Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before release. Are you satisfied with your attorney so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed so far in this trial? All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Ooh, that's interesting. That's very interesting. That's just a great way to say, like, hey, you try to appeal. That is a very, 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 very interesting. Well played, Judge Kranek. Well played. I think he's going to ask her this every day, and I don't know if she's smart enough to realize why he's asking it. Could she refuse to answer that? She could say, I assert my right to remain silent, certainly. But at that point, then it would be clear she's fucking around. So, yeah, but you always have the right to remain silent. You can decline to answer questions. I mean, what's he going to do? Put her in jail for contempt? So what happened there? He just made her establish, I'm satisfied with my counsel. I'm satisfied with their strategy. This is to prevent her from later on at trial saying, like, they're not doing what I want. I think it's also her way of preventing her from making a scene and trying to fire them. It's also trying to insulate himself on appeal. So he's going ahead he's insulating the record right now. And what happens if he says, no, she isn't happy? Well, that might change a lot. Like, what's going on here? Although I think he clearly knows that they're doing this in a way she's happy with. So he wouldn't have asked that question if he wasn't going to get an answer he didn't like. So, yes, it's Judge Ted Cruz, the Zodiac Killer. All right, so we're going to skip lunch real quick there. We got some other super chats and things to answer here. Nico's been remembered for 11 months. He says, 11 reminds me of that tragedy with the thermite paint. Yes. And Squinty Cat for $20 says Clyde coin. Yes, chat. Clyde coin's going to the moon. Yes. And then Joe Lloyd for 10 pounds sterling. The King Sterling says investing in Clyde coin. It is never a bad time to invest in Clyde coin. Get a Clyde coin backed IRA. Do it, guys. Do it. You know, as they say in German, auf der Mond. Yes, off their moon. It's all gas and no brakes on the Clyde coin train. Eric is saying that wasn't a good witness for the state. Yeah, but it wasn't critical. Like, the defense didn't get what they wanted because it sounds like there was fighting. But I don't think the state's really contesting the idea that they weren't fighting and these guys both weren't pieces of shit to each other. I don't think that changes their case at the end of the day. Because it just, Sarah did it. She didn't have, like, George being an asshole isn't enough. But I understand your argument. And then Midnight in Exile saying, what's the defense's theory? Basically, George got stuck in the suitcase, and he's like, if you let me out, I'm going to fucking kill you and beat your ass. So Sarah panicked and, like, smacked his hands and shoved him back inside the suitcase and locked him up in there. She was just trying to stay away. And in the meantime, she kind of got drunk and passed out, and George suffocated. So it was kind of like all the PTSD caught up to her. Basically. Kind of like it's a very obscure self-defense claim. So I don't think it's really going to work for them, but that's what she's arguing. So I'm dressed for surgery tonight, yes. And then went to bed, which is kind of dumb. Yeah, but these guys, like, think about all the wine they were drinking. These guys sound sloshed. Like, think about how fucking wasted they were. Midnight says, I want to see the suitcase. You will see it. I think you see it today. But yes, this 100%, you know, we're going to skip ahead here. And I'll let you guys watch while we're going. No lunch for chat. And we are going to pop out at, here we go.
Same black suit and pink blouse from this morning. State anything we need to address before we bring back in our panel.
Can we get the evidence protection system up and can we test it before we
Yes.
go live?
Yes, sir. If you want to test it out, Mr. J.
Call 1 at 12:59 p.m. with a GMT offset of minus 300 minutes. Call on month. Call 1 at 12:59 p.m. with a GMT offset of minus 300 minutes. Call on Monday, February 24th, 2020.
911, what is the location of your emergency?
That is the best I can do, sir.
What's going on? Hold on here.
This is a member of that. To my right and my left.
Oh, here we go.
All right. Just in the spirit of full disclosure, there are some persons behind me to my right and my left. I run the mock trial program at Barry University School of Law here in town, and these are some of my students as a member of that program, so they're here just simply to observe. So pay no mind or attention to them. With that, are we ready to bring in our jury?
Yes, Sean.
Yes. All right, let's stand and bring in our panel. Members of the jury, good afternoon. I have questions that we.
All right, let's go. Okay. Brian Boone. Brian Boone.
Mr. Boone, raise your right hand and sworn, please. You swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes. Sir, good afternoon. You could be seated. After seated, if you could please state and spell your name for the record for us.
Brian Boone, Brian Boone.
Thank you, sir. You may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you know the defendant?
I dated her for quite a while, and then we eventually got married.
When you say you dated her for quite a while, how long are we talking?
I met her in the late 90s, and I believe it was around 2005 when we got married.
Did you have any children as a result of your marriage with the defendant?
Yes, we had one son.
And how old is that son?
He is currently getting ready to turn 14.
Okay, chat. 2.0 thinks that's a toupee. Do you guys agree? Yes or no? 1 yes, 2 no. That's some weird looking hair.
Did your marriage with the defendant last?
And no, it did not.
And approximately when was it that you separated and began proceedings for a divorce?
Probably 2017, I'm thinking maybe.
And at that time, when was your divorce actually finalized?
Maybe it was 2006. I think the divorce was 2017, I believe.
And after your divorce, what was your custody arrangement with your son that you had in common with the defendant?
She was supposed to have him on Mondays and Tuesdays. I would have him Wednesday, Thursdays, and then we'd alternate Friday through Sundays every other week.
So 1 week you would have 5 days with your son, and another week she would have 5 days with him.
Correct.
And was this still the same custody arrangement in February of 2020?
Yes.
And in February of 2020, did you have, do you recall the events that occurred, I guess, first on the late evening of February 23rd, 2020?
On that evening?
Yes.
Well, apparently, Sarah called me at one point during the night.
Do you recall about what time she called you?
I think it was 11 something.
When you answered the phone, how did Sarah sound on the phone?
She sounded like she had been drinking, was pretty drunk.
Were you able to understand what the defendant was saying?
Somewhat, but she woke me up. I had work the next day. I was asleep when she called. She's done this before, calling me late at night, and generally I kind of just try to ignore it, so I wasn't really paying attention.
Who was she living with at the time?
Jorge Torres?
When she called you late that evening, could you hear George in the background at all?
Not that I remember, no.
Did you pay much attention to this phone call?
No.
Now, the following morning, on February 24th, 2020, did you begin to call the defendant?
Yes, I did.
And approximately what time did you begin to call the defendant?
I think it was like 11 o'clock or something.
And why was it that you were calling her?
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was calling to try to find out if she was going to be actually picking him up that day.
Why would you have a question about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
So it was not uncommon for you to have to remind her to pick him up or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Do you remember at what time on February 24th you actually got in touch with the defendant?
It was like 12:30 or something.
And when you actually got in touch with her, what did she tell you on the phone?
That George was dead, and if I would come over.
Did she say what happened to him?
I don't remember if she told me then on the phone or when I got there, but she told me they had been playing hide and seek and that she fell asleep.
What did you advise her to do?
I told her she needed to call 911 and that I would come over as soon as I could.
And this is on your first phone call here at approximately 12:30.
Yes.
On 2/24/20.
Yes.
Did she call you again while you were en route to her residence?
She did. She called to find out if I was still going to be coming over.
And when you spoke with her while you were en route, what, if anything, did you advise her?
I told her she needed to call 911 and told her I was on my way, but she needed to get somebody over there.
How long did it take you to arrive at her residence?
From the first phone call, or?
Yes, from the first one.
I mean, I live a minute or two drive away, but I had to get my puppy. We had just gotten a puppy recently. I had to get him in his crate and stuff like that and put something on because I was working from home. And total time, maybe 10 minutes.
When you arrived at her apartment, tell us what she told you when you arrived.
George was dead, and once again, I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep. But I, at that time, told her again she needed to get 911 called to get somebody over there.
Had she called 911 at this point?
No, she had not.
So you've advised her now 3 times to call 911.
Yes.
Did you go inside of her apartment?
I walked in the front door into the little tiled area, like entranceway thing.
What, if anything, did you observe when you made it to that point?
Looking into the living room, I could see like the end of his feet and maybe a little bit of some legs that were kind of coming out around the backside of the kitchen area.
Did you continue to go into the apartment?
No.
Where did you go?
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her. And I told her that I didn't really feel comfortable being inside. And I went out front and got in my car and waited for people to show up.
Did you witness the defendant call 911?
I think I was in there when she dialed it and first got somebody on the phone, but I wasn't there for the whole conversation. No, I was outside.
Did you stay there at the scene while police arrived?
Yes, I was there. I was part of it. I knew I'd have to talk to somebody, so
Did you talk with law enforcement?
I did.
Your Honor, I have no further questions at this time.
Thank you. Any cross-examination?
Judge, we want to reserve our questions for when we call him in our case.
Okay. All right, sir. You're subject to recall.
That's interesting. They're not even going to ask him questions. But apparently Sarah just couldn't leave it alone. That's interesting. Also, yeah, I don't know. This guy's that was interesting testimony. That was interesting.
Okay.
Sarah's a little clingy. She likes them drunk dials.
Thank you.
Thank you.
Just as long as he remains under subpoena.
My understanding is subject to recall.
So somebody will contact me about.
Oh, I think
Yes,
so
sir.
too, Dweez.
Thank you, sir. State, you may call your next
Oh,
witness.
okay. That's interesting.
Your Honor, may we approach a moment?
Yes.
That's interesting. Did not know that. Well, Afton, they can ask him questions, but they have to be very careful with what they can ask. I mean, there are things they can ask him, but it's just, I have the feeling they're going to try to say, like Sarah indicated to him, that she had been abused and that she was fearful of George, things like that, which that wouldn't cause a, that'll be probably as part of their self-defense bolstering, which I agree with you. But they could ask him questions right now. They could have asked him questions based off what he said.
Members of the jury, we'd appreciate your patience for a few moments while.
So I agree. They could ask him questions. They can't ask him questions about, did Sarah ever say George beat her? Is she afraid of him? Stuff like that. So yes, he's going to come in after Sarah testifies.
The state attaches a Bluetooth speaker so that they may publish some evidence that's been
Yeah,
received
so he has all
far.
the tea on the combat. There you go. I guess I'm catching up
Mr.
there.
J, whenever you're ready, sir.
Permission to publish 3?
You may do so.
He's paying alimony in an escrow account. Oh, God, there's a lot of money there. I bet. Job well done says that's not your pounds, Jorge. I know, but they keep calling him George, and his name's Jorge, so I don't know. I guess they call him George. Whatever. I don't know. People go weird, name themselves in weird ways.
February 24th, 2020.
911, what is the location of the emergency?
4748 Brent Court, apartment 3.
4748, what's the street name?
Brent, RANTD.
And the appointment number?
3.
Is it the police or medical?
My boyfriend is dead.
Okay, then the line for the flight appointment will not hang up. That's good.
No, we don't need
4748 Brent Lane, apartment 3.
Brent Court.
Brent Court?
Yes.
Okay, is this near Mackenzie Drive?
I don't know where that is.
Okay, fair.
It's still with our apartment.
Okay, 4748 Brent, correct?
Correct.
All right, correct. Now tell me exactly what happened there.
My boyfriend and I were playing last night, and I played him in a case and we were playing. And but kind of hide and seek kind of thing. So I fell asleep and I woke up and he was studying the suitcase. So I don't know what happened. I don't know what happened.
Right, okay, what's your apartment number?
3.
Number 3?
Yes, like he had like blood coming out of his mouth, and I don't know, like he had like an aneurysm or what happened.
Right, okay, all right, okay. So we're getting on the sheet. All right, okay. Okay,
Now?
okay, 407, this is water, we're there. You have 407-716-8684. Okay, is he hanging from somewhere or what, man?
No, I pulled him out of the suitcase. I tried giving him CPR.
Okay, so he was in a suitcase?
Yes, and I fell asleep.
Okay, how old was he working there? 42-year-old man. All right. Okay, we're checking up on the sheriff's office around there?
Yes, ma'am.
Yeah, okay. All right, listen to me. Okay, that you need to confirm this. No, right, I need you to confirm this.
You see awake at all? Is he conscious at all? No. He's purple. Is he breathing? No. All right. I need you to get him on the floor, down his back for me, okay? I did. I tried to get him into the yard. All right. I tried to get him into the yard. Yeah, okay. Well, nothing happened. He's purple. But, okay, listen, he's in the defense of the bill. I need you to get it for me, okay? What is it? Will you be available? No. All right. You write by him now? I'm sorry? Are you right by him now? Yes. Okay, okay, ma'am, listen, so is he cold and stiff? Yes. Okay. Well, it's not necessarily cold, but he's stiff. Right, okay. All right, listen to me. Listen, I want you to lay him flat his back for me on the floor. I did. Remove the pillows, okay? Yes, I did. All right, okay. Wait. Purple. Right, okay, listen, okay, man, that's fine. We're still looking for two compressions to him, okay? All right? If you look your hand on his breastbone, right in center of the chest, right between the nipples. Yes. Would you have hands up on that hand? Ready, I'm telling you. There's something I can tell. Okay. Please, okay, your girdle. Okay, listen to me. All right, I want you to place the heel of your hand. Okay, right between his chest, right between his breastbones. Put your other hand up on that hand. We want to pump his chest to be hard and fast. Go ahead and do it twice per second. Okay, no, just keep on pumping it. All you need to do for me. Keep on pumping his chest over it. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. This is 19. Okay, man, just keep on pumping his chest. That's all you need to do for me, okay? Yes. Come on, please, hurry up. Okay, man, they're driving here as fast as they can. Okay, don't stop and say hurry up. Just keep on pumping and counting. I'm still doing what I'm pumping, okay? Still doing it. All right, just keep pumping the chest. Count up, take a count with you. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32. Please hurry. Okay, man, just get here as fast as they can, okay? He's stiff and he's purple. Okay, keep pumping his chest for me, man. I'm still doing it, okay? Still doing it. Still doing it. Right, okay, that's fine. You do the job. Just keep on doing it for me. That's all right. They're getting as fast as they can along with the sheriff's office also, okay? Please. Keep on pumping, man. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. Keep on pumping for me, man. I'm doing it, okay? We're going to play hide and seek. All right, I understand. All right, keep on pumping for me, okay? Okay. Please hurry. All right, okay. Horrible. This is horrific. What happened? Like, what happened? Okay, man, keep on pumping the chest for me, okay? They're in the parking lot. They should come up there shortly, okay? I'm still doing it, okay? All right, okay, good. And you found him in a suitcase, you said? Yes. We were playing hide and seek last night. I fell asleep. I think they're good. All right, keep on pumping the chest until they get over, okay? Okay. 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 Okay, come in. Where's my puppy now? Let that take over for you, okay? What was the last time anybody saw him? The last night. Go play hide and seek. He was the potato. Okay. Unfortunately, he's been down too long. There's nothing to do. Hello, ma'am. So we're there, obviously. No, not that. Hey, man, it's not supposed to take you, okay? Okay, so we'll see you there. All right. Oh, ma'am, still there? Hello? Contact 407-716-8684, reference woman. 1308. Call has been forwarded to an automatic voice message system. 4
we're ready to continue with the presentation of witnesses.
Yes, sir. You may call your next witness.
State we call Abraham Moreno.
Mr. Moreno, raise your right hand and sworn to the swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I affirm.
Sir, good afternoon. Could you state and spell your name for the record for us?
Abraham, Abraham, last name is Moreno, M-O-R-E-N-O.
Thank you, sir. You may be seated. Mr. Castro, you may inquire.
Good afternoon, sir.
Good afternoon.
Tell us, what do you do for a living?
I'm a maintenance supervisor for apartment complexes.
Is that what your position was back in February of 2020?
Yes, it was.
And what apartment complex?
Tealwood Park Apartments,
And how long did you work for Tealwood Park Apartments?
about 2 years.
And tell us, what were some of your duties in your position there with Tealwood Park?
Daily, I cleaned the grounds, walked the property, answered maintenance calls, did emergencies, dealt with vendors.
Did you become familiar with the residents there at the apartment complex?
Yes,
Did you have occasion to meet the defendant in this case and also a Jorge Torres?
yes,
Let me turn your attention to February 24th of 2020. Do you recall that date?
yes,
And on that date, did you have occasion to come in contact with the defendant in this case?
yes, I did.
And tell us, what was the circumstances in which you came into contact with her on February 24th, 2020?
I was called by the manager and the assistant manager to come to her unit. I believe she was already sitting outside at that time.
And when she was sitting outside of her unit, what, if anything, did you observe about her and about the unit?
The police was there. Her ex-husband was present. She was sitting outside, and that's when she decided she wanted to talk to me and managers.
And what did she tell you?
She's confused. She's not exactly sure what happened. She pointed out that she recalls that they were playing a game of hide and seek. There was an instance where you were going to teach him a lesson, and then she just doesn't recall anything else until the next morning.
Did she say she fell asleep?
Yes, she did.
Did she say things got out of hand?
I don't really recall that part, but I do recall her stating that they were playing their game and that George went into a suitcase. And I didn't ask any questions. I just let her talk for herself
How long was this conversation?
for about 4 or 5 minutes.
Your Honor, I have no further questions at this time.
Any cross-examination?
Yes, sir.
Sorry,
You
guys.
may inquire, sir.
Sorry.
Good afternoon, sir. Good afternoon.
I thought I took
This
it down.
conversation that you had with Miss Boone? Yes. That took place on the 24th.
I'm sorry, Chad. I thought I took it down. My bad. Sorry.
Is that correct?
Oh,
Yeah.
I forgot to change the banner
And
out.
who else was present on the time that the conversation was taking place? Standing right next to me would have been Melissa Sexton and Eugene Harris, as well as the officer who was in front of the door. Okay. So there was a law enforcement officer there that day, is that correct? Yes.
Yeah, are they going to make this a... Where are they going to go with this?
Now, on the 24th is when you said that Miss Boone made this statement to you. Is that correct? Yes. They were playing hide and seek? Yes. And what else did she say happened? She had told me they were playing hide and seek. They had drank. She was trying to teach him a lesson, and that was that. She went upstairs. She went to sleep. She woke up. She doesn't know what happened. Okay. So that was on the 24th? Yes. All right. On the 26th, were you not interviewed by law enforcement? Yes. Okay. So I may have my days wrong, but it all happened on the same day. All right. The 24th, do you remember 2 days later that a Detective Scott Lowen conducted an interview with you at 4704 Lucier Court, Winter Park, Florida? You remember that interview? Yes. So that was 2 days later. Is that correct? I would assume so. Yes. All right. So when he interviewed you 2 days later, did you tell him about this statement that Ms. Boone made to you that you just told this jury in court? I did mention it to him. You did mention it to him?
I mentioned to them that we did have a conversation.
Did you tell them the content of the conversation?
I may not have told him the whole content, but I did tell him we had a conversation.
All right. Well, what did you tell him? What content did you tell him on the 26th?
That they were playing hide and seek, that she was confused. She doesn't know what happened. I do believe I did mention to him the fact that she had said that she was trying to teach him a lesson. Not that anything was done with malice. I didn't say that at all.
Okay. So it's your recollection now today that on the 26th, you told Officer Lowen what you just told this jury. Is that correct?
Yeah.
All right. Sir. In preparing for this case, did you have a meeting with the Assistant State Attorney on September 23rd of 2024?
Did I have a meeting?
Yes.
A brief chit chat over the phone.
A brief chit chat goes over the phone?
Yes, sir.
All right. At that point in time over the phone, did you tell him that Sarah Boone, the defendant, stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
Yes.
Is that what you told him?
Yes.
Okay. And that was in 2024 of September the 23rd of this year, 2024. Yes. Is that correct?
Yes.
Are you telling us that back on February the 26th of 2020, you told Officer Lowen at that time the same thing?
As I recall, yes.
So did she ever tell you how things got out of hand?
No.
Sir, you testified that you knew both Mr. Torres and Miss Boone, is that correct?
Yes.
You actually knew George Torres from a different time, didn't you?
Yes, I did.
When did you first know George Torres?
In the 1990s.
In the 1990s?
He was a teenager and he lived down the street from me and my wife.
So you had a previous relationship with Mr. Torres?
No, not at all.
Not at all.
Now you're.
You just knew him from then?
Yes, as I stated, he was a teenager and I was an adult.
Okay. During this time, though, that you became reacquainted with him, did y'all establish a friendship at that time here in Orlando?
I wouldn't say a friendship, but an acquaintance, yes.
Okay. Sir, on Monday, February the 24th, that would have been the day that you were with Ms. Sexton and Gene Harris.
Yes.
Out in front of the apartment.
Correct.
Did you talk to law enforcement that day?
No.
You did not talk to them that day?
I don't recall talking to him that day, no.
Okay. Thank you, sir. I don't have any. If I can confer.
You can answer.
Thank you, sir. I don't have any further questions.
Any redirect examination?
Just brief.
All right, thank you.
Back in the 90s, when you had previously known George Torres in this case, where were you living at that time?
I lived across the street. I lived on one block. He lived the next block over down in the middle.
In what city?
Philadelphia, Pennsylvania.
And when did you move from Philadelphia, Pennsylvania?
2018, I believe.
So in the intervening years, from your move from Philadelphia to coming to work at Tealwood Park, did you have any contact with George Torres?
No, as a matter of fact, I moved from that particular block in 2005, so I don't meet Judge again until I work at Tealwoods.
When did you start working at Tealwoods?
2018, 2019, roughly there.
No further questions.
Can this witness be released?
No, Your Honor, just subject to recall.
All right, sir. You'll be released subject to recall. Thank you.
Thank you.
State, call your next witness.
State will call Deputy Kayla Rodriguez.
So that guy's their meth dealer. I kind of, yeah. I wonder what his relationship is at the end of the day with them. I think he's involved with them. I think he's involved with that more. Brewberry says, "Does no one dress up for court anymore?" No, nobody dresses up for court. Most of the witnesses, like the jurors, are going to be sitting there in jeans and t-shirts and stuff. No, nobody. If you're not a witness, if you're not a party in a case, yeah, nobody dresses up for court.
Good afternoon, ma'am. You could be seated. Please state your name and spell it for the record if you could for us.
Kayla Rodriguez. Kayla, Kayla, Rodriguez, Rodriguez.
Thank you. Mr. Castro, you may inquire.
Good afternoon, ma'am.
Hi.
Can you tell us who is that you work for?
Orange County Sheriff's Office.
And what is your position with the Orange County Sheriff's Office?
Deputy Sheriff.
And how long have you been a deputy sheriff?
A little over 8 years, since 2016.
And tell us, what are your duties as a deputy sheriff?
As a deputy, I respond to calls for service, anything from a over with call, like a car being keyed the day prior, or a 911 emergency.
And what type of training do you need to be a deputy sheriff?
So for me, I obtained my bachelor's degree from UCF in criminal justice in 2014. After that, in 2016, I was hired by the sheriff's office. Right after being hired, I went straight into the academy. The academy of training, we go over everything from case law, scenarios, defensive tactics, physical training. After that, I do 2 more months with the sheriff's office where we go specifically into policy related to Orange County specifically. After that, I do 3 months on the road with a trainer where we are evaluated periodically through that process. You have a partner, you respond to calls for service during that time, and you slowly learn how to handle calls by yourself.
Do you also undergo continuing training as a condition of your employment?
Yes.
Tell us, what were you working on February 24th, 2020?
Yes.
And tell us, what area of the county were you working in?
Orange County, unincorporated Orange County.
And did you receive a call in regards to this case?
Yes.
And what was that call? What information did you have at the time you received the call?
So the dispatcher informed me that a woman called 911. She was actively performing CPR and that her boyfriend was in a suitcase.
And did you respond out to the scene?
Yes.
And when you responded out to the scene, were you dressed similarly as you are dressed today?
Yes.
And just for the record, you have, it looks like a standard green uniform on with a tool belt, your firearm, and also radio, body-worn camera, badge.
Yes.
Tell us about your body-worn camera.
She's the perfect height to enforce manlet law. Yes. Sir, I'm at your eye level. I too am a munchkin. I can tell you what to do. Oh, Jesus. Oh my God, you guys.
So my body camera is used to capture scenes when we arrive. So as we are conducting any sort of a law enforcement action, we turn our camera on.
When you turn your camera on,
I do like this idea that body cam's up higher because it gets you more in line of like how and where you're looking. I do like these a lot better than like the ones mounted like right in the middle of the chest.
tell us, does it immediately capture sound at that?
Familiar with the
It does not. When we activate our camera, it goes back a minute, and the minute that it goes back to, you don't hear any audio for that first minute.
Tell us also about the capacity and the battery life of your camera as well.
So the battery will last us an entire shift, typically, if it's in a buffering mode. So if we're not recording, it will last the entire shift. As we record, it does drain the battery. So typically we will turn it off if we're sitting in our car for an extended period of time. If we call our supervisor, if we're talking to another deputy on the side, away from a scene, we will not have the camera recording. If it recorded throughout the entire shift, the battery would die. We would need multiple batteries.
So you actually activate the camera in order to begin recording?
Correct.
Was your body camera operational on this call out?
Yes.
Your Honor, may I approach the witness, which has been previously marked for identification as states H, I, and G that have been shown to defense?
You may.
Ma'am, I'm
Don't let
showing
Mercy
you
see
what's
this
been marked
chick.
for identification as states I. Do you recognize that disc?
Yes.
Did you have an opportunity to review that disc prior to coming to court today?
Yes.
And tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24, 2020?
Correct.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of your body worn camera?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states I into evidence.
Any objections?
No objection.
All right, what was pre-marked as I will be received into evidence without objection as states 4.
Okay, I never saw this guy's tie, but this like candy cane tie with the cream suit, I don't know about that, man. It's also a 3-piece suit. You guys notice that? Like, he's got this, like, it doesn't even look like it's striped. It's also like striped and cross-hatched in the stripes. But like, I like the suit, but like this tie does not go well with that suit, I think. I don't know.
Any objections?
No objection.
All right, what was pre-marked as I will be received into evidence without objection as states 4.
Most men's
And next,
suits
I'll
have
show you what's been marked for identification as states 8.
most men's suits have shoulder pads. That's kind of just how they're cut.
You take a look at that disc. Tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24, 2020?
Yes.
And did you have an opportunity to review that disc prior to coming to court today?
Yes.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of that portion of your body worn camera from that day?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as states H into evidence.
No objection to any of those coming in.
All right, what was pre-marked as states H will be received without objection as states 5.
And lastly, ma'am, I'm showing you what's been marked for identification as states G. Do you recognize this disc?
Yes.
And tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24, 2020?
Yes.
And you had an opportunity to review this camera prior to coming to court?
Yes.
And that's your initials on the disc?
Yes.
And it fairly and accurately represents your conduct on the body-worn camera?
Yes.
Your Honor, this time I'd like to move what's been marked for identification as states G into evidence.
No objection.
Thank you. What was pre-marked as states G will be received without objection as state 6.
In Your Honor, request permission to publish states 4.
You may.
Your Honor, maybe dim the lights and use the overhead projector.
Yes.
Oh, whatever. Here we go, chat. This is the good stuff. This is the good stuff. And some of you have already seen this, but if you guys haven't seen it all, here we go.
Tell him really quick, or where's yeah? You want that? Oh, don't worry about that. We'll take care of that for you, okay? I had to figure out this. Okay, one second, okay? I really, great. Okay, we'll pick up my box, about the counter. Okay, you want that? At the time, What's going on? What's causing you? Yes, because of like 3.5 years. What happened? Right, last night. Can you pass it to the, around to the, you gotta stop the biggest sign, I'm sure. No, each of them has to, this might be a real thing, but each of them has to. What's going on? I decided to fill in. No problem. Together, we can do some right there. You are putting a puzzle together? Yes, we have a puzzle that we started in there. Okay. We've been doing our trying to take stuff off the wall with to make new art apparently. Having a good time with one another. But we're thinking we had a lot of wine last night. So then it's like we start to play hide and seek, right? Okay. So he gets in the suitcase. Okay. Who is this guy? That's my assistant. I told my husband. How did you live with the guy? No. I told him over here. Okay. Okay. I didn't know what to do. Okay. I didn't know what to do. Okay. So then he came over here. Yeah, let's talk about it. I called you guys. The problem is, I fell asleep. When did you do CPR? This morning. When I found it before you called. Yeah. Let's talk right now. I tried. I was awake, but I was in bed at like 12:30ish. So I came downstairs and I was like, oh, he's in the suitcase still. That's what I found, and I sent him out. I tried to CPR, and then I called him, and then I called you guys. Did he get here before the fire department got here? Who? The husband? Or the ex-husband? Okay. Where's he at? Right on the street. Okay. So you were planning to get some updates? I did, but then I fell asleep. Okay, stop. You're okay. I wasn't here. I'm just trying to figure out what happened. It's not either. Like, how many injuries or a heart attack or what? Medical condition. Yeah. Not that I know of. Not that I know of. No. All we have is a bottle of wine. Literally, just a bottle of wine. Okay. Doing puzzles, artwork.
Multiple bottles of wine. That's a big bottle of wine, though, too.
Then we decided what happened to me. That's all that happened. I go in there, but they don't know what happened. So how long were you doing CPR on him prior to talking out on that? You tried that all morning? Yes. Okay.
Yes, you should have.
I told him, well, I was not going to start probably, what ballpark. Here, let me fill this at the end, okay? Please, ma'am, I got the pepper. I'm still cutting out. Okay. Man, and you can't talk to him until we get down to the paper, okay? Just don't leave, okay, Brian? Thank you, ma'am. Appreciate it. Thank you. I know. Do me a favor. Stand over there by that car. Give me 1 second. There's a dog in there? Yeah. You want to clear the back bedrooms real quick? Just make sure there's nobody else in here? Nope, he was here with the girlfriend, and that's the girlfriend's ex-husband. He's going to see you. It'll play out. So this is what she said. She's going to do a CPR on him all morning before calling us. Yep. So I'm going to go ahead and start making phone calls. Okay, what do I do with this dog? Because I don't want him to mess with him. Come here. Oh, perfect. Okay. Yes. Hey, come on, let's go outside. Come on. Good boy. What's up, honey? You think about it, just want to make sure. Hey.
Orange County.
There's something. Right over here. We check this closet.
Check for more luggage. There might be more survivors. Oh, look, there's another bag. There could have been someone stuck in there we don't know about.
So garage.
I guess we're gonna have to set up a crime scene now.
Oh, just give us a part of the Let's get it down. I don't want you passing out. This is probably a lot for you to do, right? I can get you some water, okay? Just I want you not on the seat for passing out. I need to get some water. Okay, I'll get some for you.
Your Honor, request permission to publish states 5.
You may proceed.
Go ahead and start making the call. Now, could you go ahead and give me his last name, Torres? Spell it for me. Torres. And his first name? George, Jorge. Jorge. O-R-G-E. His birthday? 2/13/78. And this is a boyfriend? Yes. How long? 3.5 years. Living together that whole time? Yes. Okay. And your last name? Boone. Spell it B-O-O-N-E. First name? Sarah. S-A-R-A-H. Birthday? 10/10/77. So you had a second to calculate yourself. Tell it to me again. You guys were playing last night, drinking a bottle of wine, putting us together, doing artwork, puzzle artwork, doing a bottle of wine, and they started to play hide and seek. So he what time was that? Do you remember? I mean, I know that I was in bed probably by like what, 12:30? Okay. Well, I went upstairs at least, and I fell asleep, forgetting that he was in the suitcase. Playing the hide and go. Yes. And at some point you put him in the suitcase? No, he got in the suitcase. So he thought it was fine to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll dig you up and make him, score a little bit, whatever it is. But then I fell asleep. I fell asleep. Where was the suitcase? Right where it is. Right down there? Yes. You dipped it in there? Yes. You funny a little bit? It was. We both were laughing about it. Okay. And then I fell asleep. Where did you fall asleep at? Upstairs. In your bedroom? Yes. Okay. Totally forgetting that he was in the suitcase still. Okay. And then came back downstairs? This morning, or this afternoon, yes, when I got up. What time? 12:30-ish. I was awake, but I totally forgot that he was in the suitcase. He can tell you there's a lot of things that we didn't go jobs. Yeah, he did tell me. Right, all that good stuff. So I just totally forgot. You introduced CPR on him? Yes. Yes. About what time did you start doing that? No, it was the afternoon. It was afternoon because I was awake. But then I finally started to come downstairs at like 12:30-ish, whatever it is. And I was like, he wasn't moving, nothing was happening, so I unzipped it, took him out and started doing CPR on him. He was on his way over here. I called you when he got here. Once he got here, you called? Yes. Okay. And air was coming out and he was gurgling, but I could tell I wasn't at him. You had to do CPR, you doing that on your own? Yes. Okay. And then the person that was on the phone with me also, I counted with him doing it. And he's got no medical, he doesn't take any medication? I don't know. I don't know medical-wise. I know he doesn't take any medications whatsoever. Okay. The only thing, like I said, I don't know if alcohol has to do with it, but we had a bottle of wine. Okay, all right. Here, I'm going to sit back down because I have one more sip of water. Yes, go on. I'll do what I can to get you a cup. I don't like to have to do that. The cups are like right there. Right there. I'll talk to the ex-husband. Oh, I won't. Can I have a cigarette, please? Ma'am, I can't. Take maybe another half. It's on the back porch. Oh, all of it. Secure, okay? I'll try my best to get you what you need, okay? Maybe one of these extra packs from someone, sit down and I'll try to get you what you need, okay? Just cut, please. Okay. I don't want you on your feet. Yes, you put it on the second. He came back in? So there's no thanks then. Hold on, I can give you a rundown. She's sitting on her. I was getting ready to call you guys. Yeah. Want to talk over here?
Your Honor, request permission to publish State 6.
You may do so.
I'm sure the detectives are like, wait, what happened? He's in a suitcase? You're like, how the hell does that work? Like, I'm sure they're like, you got to be shitting me. This is all like a prank. Like, I don't think they believed him when they heard it, but we'll see. Yeah, there you go, guys. See, for guys with your foot fetish, we already addressed that. For you guys who are prego people, here you go. the pregnant detective. I'm glad I can't know that most of you guys, how many of you are out there whacking it right now.
Hey, Sarah. You get enough water? No, you want to stay seated.
Yeah,
I don't want you to get lightheaded.
This is a good point. They're thinking, oh my God, she cut him up.
The detectives were going to come out and talk to you and go from there. You know what I'm saying? They're here. They're going to ask you a few questions and then go from there, okay?
It's
All
too
right.
much
Hi, Sarah.
coon.
My name is Chelsea. My partner Scott. To my understanding, you reside here? Okay. Is it just you? Okay. Your former husband. Okay. But you reside here with George, and then your son lives with you, or lives there 50-50. Okay. So from what has told me, she explained last night that you guys were drinking a bottle of wine, and around midnight, you decided you guys. Okay. You guys decided to play hide and seek.
Well, we were playing hide and seek, and then
was your son home?
Stacy, thank you. Stacy's with the actually. Don't ruin their gooning. Don't ruin the gooning here, Stacy.
At the time, or okay,
no, it's fine.
It's fine. Okay.
Decided to play. We just did it like that. Like, we were huddled together. We were doing artwork. You can see the puzzle that we finished in there, and then the artwork, and then decided to play hide and seek.
Okay.
So he decided to get in the suitcase. So I thought it would be funny to, and he was talking about it too, to get him up in there. I go upstairs and he fell asleep. So this morning when I got here, I actually got up out of the bed. I thought sure he was downstairs on the laptop. He was really quiet. But then I came upstairs and I'm like, where is he? Like, and that's what I found.
Okay.
I don't know what happened.
Okay. And then you weren't sure about if you woke up this morning.
It was afternoon. I mean, I was
this afternoon.
but I didn't want to come downstairs. So I just laid in bed for a little while. And then I eventually came downstairs. He was where he was. And then I was like, oh my God. So I pulled him out and I pushed him out and I started to check in CPR point. I told you guys. So I told Brian. Okay. And then as soon as he got here, which is the first thing on the road, I told you guys. Okay. The person on the phone had me do the concussions potentially. So I come with that. So you guys shut up.
Okay. And so as part of our investigation, we obviously have to go inside the house. We have to look at things. Are you okay with us going in the house and looking at things? Okay. And forensics, so we have to have our forensics crime scene investigators come out. Are you also okay with them coming inside, taking photographs and? Okay. Okay.
Can I ask, is Brian, George, was he diagnosed with any kind of mental history?
Not that I know of. Not that I know of. I don't know. I mean, it doesn't take for us. I mean, how many people are wine in there? But I don't know.
Like, my next question. So you guys don't normally drink? You just drink once in a while, or?
Well, I'm gonna say like, okay, I guess normal drinking is like we will have like a glass of wine or two, like when we're cooking dinner. I'm sure we'll have a beer and say that's working with them. But it's not like. I don't understand though, like, for the little bit that we had, like, not having an issue. Like, I don't know if they had a heart attack or a stroke or anything, or what happened. I don't know.
So were you guys together all day yesterday? Okay. Here, like, either of you left the apartment yesterday?
We rode up before to get cigarettes.
Okay.
But you can walk there.
This guy, no, he doesn't now. He said he doesn't.
I don't know.
As far as you've ever done, never seen him.
No. I mean, he's from Philadelphia, and he grew up in Philadelphia, and then he went to Massachusetts, and then from Massachusetts came down here. So I don't really know, like, a whole lot of, like, medical history or
How long have you guys been together?
Almost 4 years, like 3.5 years.
You guys been living here the whole time?
Yeah.
You've never been to the doctor or the hospital during that time?
He and his brother got into a really bad argument at one point and had facial reconstruction. But he hasn't been in the hospital from that. And then I talked him into going to see like a regular physician so he could get like a regular like checkup thing. Yeah. But they were no like right.
How long was that?
The surgery or the doctor? The surgery, I think it was like 2 years maybe, 2.5 years. The checkup was probably a good 2 years too.
Okay. And the suitcase is still in there?
Yeah, I'll
Okay. Is it normally stored down there, or did you guys travel recently?
No, me, but I start picking up the donation in there, so that's why.
Now? Okay, you guys did recently travel somewhere and going on?
After you set the butt, did you move the bag around and after that, or you just sit around and walk away?
I went upstairs, my cellar key.
What position was he in when you put it, when you went in? Was he sitting on the rear end and his head up and he just kind of?
So like this is like this is the side of the right here.
So he was laying on his side?
Yes.
You just closed the flap and zipped it around?
Yes.
Okay.
I think we're cleaning.
Okay.
So he said that I needed to tell you guys about his family. Like, who do I talk to about?
We're gonna do that once we walk through and see. Yeah, we're gonna.
I'm just telling you, like, I'm afraid for my life. I want you to know that. I am afraid for my life. His family has never liked it. I'm really like white devil, what they call me. So they never.
Hold on here, Chad. I want to hear that real quick. Did she say, I fear for my life? She's like, I'm telling you, like, I'm for my life. Did she say she's fearing for her life? Hold on.
I'm just telling you, like, I'm afraid for my life. I want you to know that. I am afraid for my life.
Oh, so she is afraid for her life. She is saying that right off the bat. Well, that's good. That helps her a lot. That does actually help her.
His family has never liked it. I'm really like
Oh, she's saying her family's going to kill her. Ah, well,
white devil, what they call me. So they never liked me. They never take me in. They never accepted me. I'll put it that way.
Have you called any of them?
We talked to his daughter just today.
No, I mean, like, about this.
No.
Okay. So no one's gonna know until we will be making that notification. So
They're going to
it's,
kill me.
okay, well,
Yes, they're down the road. They're going to kill me. His kids are going to kill me. They're going to kill me. This was not intentional.
Okay.
They're not going to understand that. They're not going to accept it.
we're gonna do a thorough investigation. We will definitely make sure that you don't feel scared when we leave. Okay?
And my 9-year-old.
Or he's at school, and he's with your husband.
we'll get to this.
Your husband said that, your ex-husband said he made arrangements for your 9-year-old to pick up.
Oh, okay, Mom.
All right, we're going to go outside.
So I know what's going on.
All you have to do is get their attention if you have a question you need to talk to us. He's standing right there, she'll be right here.
Yeah, okay, but when you guys tell me, like, so you're telling me, like, you won't call whoever it is without telling me, right? I mean, I have all the.
We're not calling, we're not making phone calls, we're actually gonna speak to them in person.
Yeah.
We
That'll
are.
be later.
It'll be later.
Prior to us making any
I'm
calls.
not gonna be here. They're going to kill me.
We'll address all of that, okay, before we leave.
Okay? This was.
Okay? Thank you.
Just stay seated, okay, sir? I know you're panicking, okay? Just relax. I'm gonna talk to you. We'll keep checking on you. Yeah.
While you were at the scene, did you also make contact with Brian Boone?
Yes,
Did you take a statement from him as well?
I did.
Were all your interactions with the defendant on that day captured on your body-worn camera?
Yes.
I have no additional questions at this time.
Thank you. Any cross-examination?
No question, Judge.
Is this witness released?
Yes, Your Honor.
All right. You're released, not subject to recall, ma'am. Thank you.
Thank you.
Can the parties approach for a moment?
All right, chat, let's see. Real quick here, I want to answer a couple questions Hella brought up real quick. Guys, Hella doing hearsay for days every Sunday at 4 p.m. Eastern time. She says, opinion on the opening statements. The prosecution's was kind of like average. Defense sucked. Not impressed. Not impressed. Scam, like it says, we're doing real Discord gooner hours. That's not something to be proud of, chat. Don't be proud of that. And Sarah says, I'm surprised the state played, or Hella says, I'm surprised the state played this. If the state did not play this, oh my God, that would look awful. You've got to play this. This doesn't really hurt the state that much, but if they didn't play it, the defense could say, why did they hide that from you? Why did I have to play it? Why did I have to play it? You draw your own conclusions. No, that would have been folly for them not to do it. Like, they have to play it. They have to play it. Yeah, but I understand what you're saying. And Stacy says, yeah, that officer would have been great at public relations. Oh, yeah, she would have been phenomenal at it. She would have been phenomenal at public relations. I think so. She's very nice, very personable. I think she'd be a very good PAO, public affairs person. So let's see what they're going back to here. You're not Sarah. You're Sarah Connor. And also, guys, I forgot Hella is doing Sarah Boone in the evenings, I think starting at 6 every night. So if you guys want to see Sarah Boone over there, you can watch it there. So.
Similarly scheduled. All right, members of our jury, it is 3:21 at this time. We're going to go ahead and take that afternoon regularly scheduled break. I'm going to ask you to come back here in 15 minutes at 3:37. Similar instructions that I've given you previously. Please don't conduct any independent investigation or research as to person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else. I thank you for your service, and we'll see you shortly. Y'all may be seated. Thank you. Bless you. State anything else we need to address?
No, Your Honor.
Defense?
No, Your Honor.
All right, we'll be in a recess till 3:37. Thank you very much.
Okay, so we're on break chat. No breaks chat. You got to hold it till we come back here. Seriously, they look like extra judges up there. It's just very funny. I do think it's cool. He's like trying to show like, you guys are with me. It's okay, bros. But oh, and someone asked, is there like a holding cell in the courthouse? Usually in most courthouses, when you get into the back, even the ones that are connected to jails, have like holding rooms and holding cells in between the courtrooms or like in a designated area. So Sarah's not taken back to jail every time there's a break. She might be taken out of the courtroom to that area, like she has to use a bathroom or eat lunch. The judge and his squad. Oh, guys, stop. Okay, knock off the shit about Bronca. I'm a big kid. I'll survive. Don't you? I don't need people coming to White Knight for me. You'll live. I appreciate the concern, though.
Again, if you could please raise.
Sean Martinez. Oh shit. Guys, holy shit. There's nothing wrong with Bronco. We just agree to we just don't agree on shit sometimes. You're allowed to do that. This is the internet. You are allowed to have disagreements. Like, nothing to worry about out there, guys. Seriously. It's okay. I appreciate it, but no. It's just there's I disagree with how the cops did the arrest. He agrees differently. That's how it works.
Mr. Martinez, please use your
I do.
Sir, good afternoon. Can you state and spell your name for the record for us?
David John Martinez, Johnmartinez.
Thanks, sir. You may be seated. Thank you. You may inquire, sir.
Good afternoon, sir.
Good afternoon.
Tell us, who is it that you work for?
Orange County Sheriff's Office,
And what is your position with the Orange County Sheriff's Office?
Deputy Sheriff.
How long have you been with the Orange County Sheriff's Office?
I'm going on my 16th year.
Prior to working for the Orange County Sheriff's Office, do you have any previous law enforcement experience?
I do.
And where was that?
I first started my career with the New York City Police Department,
And how long were you with the New York City Police Department?
about 10 years.
And what was your position with the New York City Police Department?
I was a police officer.
He's a carpetbagger, chat. He's a carpetbagger.
And at the sheriff's office, tell us, what are some of your duties as a deputy sheriff?
Respond to calls of service. My primary function is the school resource officer.
And is continuing training a condition of your employment with the sheriff's office?
It is.
Tell us, how is it that you became involved in this case?
I was dispatched to this location.
And what was this location?
It was located at 4748 France Lane, apartment number 3.
And is that here in Orange County, Florida?
It is.
And when you responded to that location, who did you first come into contact with?
I came in contact with Miss Sarah Boone.
Do you see Sarah Boone here in court today?
I do.
Could you please point to her and identify an article of clothing she's wearing?
The lady sitting in the middle with the black blazer.
Your Honor, may the record reflect that the witnesses identified the defendant?
Record will still reflect.
During the time that you were on the scene, did you have a body-worn camera?
I did.
And was that body-worn camera activated?
It was.
Were all your contacts with Ms. Boone recorded on that body-worn camera?
It was.
Were other deputies also on the scene at that time?
Yes,
And was Deputy Rodriguez there?
she was.
So would both of your body-worn cameras both capture some of the same time frames?
Correct. Yes.
Did you have an occasion to go inside of the apartment?
I did.
And inside of the apartment, what observations did you make?
When I first entered the apartment, I noticed a Hispanic male laying on his back and looks like a small nook dining area. Later identified Mr. Jorge Torres.
Your Honor, may I approach the witness who's been previously marked for identification as states K and been shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as states K. Do you recognize that disc?
I do.
Tell us, what is that disc?
Is a copy of my body-worn camera.
And does this body-worn camera fairly and accurately depict the a portion of the events that took place?
You know, chat, there's been no discussion about the watermarks or anything like that. That's the true sadness here. Sarah's going to get convicted based on probably watermarks. And it's not the actual original copy. The original is stored inside that camera and we'll never get to see it. It's sad. It's truly a travesty.
On February 24th, 2020.
It does.
And are those your initials on the disc?
Yes, they are.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states K into evidence.
Any objections?
No objection.
What was pre-marked as states K will be received into evidence without objection as state 7.
Your Honor, request permission to publish.
You may. Madam Clerk, you give them the lights.
The Frankenstein hearing. Oh, gosh. What? Here we go. Come on. Come on. Let's play it. Let's go.
They're coming out now. I'll get you somebody, okay? She wants to say something. I'm going to call someone.
Don't know anything though, like why or how? So that would, we will not know the answer to that because we're not. So we're not in the office. I'll have to what's called a knock. Yeah, that'll be first thing tomorrow morning. I'll know a lot, hopefully a lot more tomorrow morning as far as him. But I cannot. There's no way I can say how, why. So just like kind of like why is it verbal? That's normal when someone passes away. But then it
There's a hard spot to be in the so most points of time, and just it becomes very so that's what happens right now.
I'm like really scared. I wish you guys know that.
We have all these evidence here, so while we're here, nothing's going to happen. Before we go make any notifications, you'll have plenty of time to read or do whatever you need to do. Okay? And we can talk about that one time. Right? Yeah, you.
But like, I don't like this was totally like not intentional. Like that's what I'm scared about too. Like.
We'll have all the answers. We'll have a lot more info tomorrow. What you're seeing here is common. This is us coming out. Yeah, it's no real medical issue that we know of. For those who have passed away, we cannot.
I know. Yeah.
We come out to an investigation. This is what we do. If he was 75 years old and had a heart condition, we wouldn't be here.
I don't know what it is.
Exactly, and that's what we're here to find out. We're just here to get the answer. The answer that you want, the answer that family don't want.
I actually went to my desk and go to my side. I mean, I know I can't go anywhere, but it's right. So do I just like sit out here and wait for you guys? Anybody else having to show up, or everybody's here that needs to be here? My team's here that needs to be here. The medical examiners will show up when we call them, but we're not ready to know yet. So they're going to take him. They're going to take the photo, take him. But that's for the end of it. And they'll be called well in advance when we're ready for them. But we're not ready for them at this point. So we won't be calling them quite yet. Okay. So like I said, I got to do some paperwork. I know they're going to chat with some people, and then we're going to come back and talk to you if you're okay with that. So just give us a little bit more time. Like I said, and you don't do that. So, like, do you guys tell his family like today or after tomorrow? You have to. So, I'm sorry, investigation is pretty much complete here. Once we get here, we will be going to.
But again, well, I'm not going to just go into it without you know doing nothing.
But how, I mean, I understand what you guys and how you do it, and, you know, so, but like, what do you just tell them? What do you tell his parents? Like, what's the reason it's away?
We know that. We don't know.
And that we're going to be waiting for the autopsy results, and I will get the autopsy in the way, and hopefully the doctor will be able to give me some of what they think and see.
Their number, they can contact them, get it, you know.
So yeah, they're gonna know what we're here, what we're investigating, and that would still, they're gonna think that okay. They always have said that. They've always have said that. I told you because I'm the blue-eyed white dragon that they call me.
Yes, chat. F in the chat. The Indian season's probably over. God damn it. Yes, the Indians are probably done now. Fuck. So, anyway.
Because they don't want him with me. So he's basically just not really been around his family because he chooses me over them. Even after I encouraged him, they were attached to next year.
I understand they get last. They're not going to make it up.
You have somewhere safe, like, you know, tonight. Both my parents are deceased, my grandparents are deceased, my aunt and uncle are deceased. I got no, I have a brother that's in the Marines, and I got another one that's in jail.
Chat, I'm well aware they have one last chance. I've also been doing this for 39 years. I know what's going to happen. And it's probably not going to be good. So, I'm just saying.
That's Murray local? No. Well, he in Altamont, but I think he's doing whatever Murray was doing. But your phone's is fine, correct? Yeah. Does he have a phone? No, he doesn't. He used my phone. He uses your, yeah, we use the sheriff. So the only place I could go is over to Brown's house. So I don't think I have a problem with it. So, well, like I said, we're not gonna leave here. If you do not feel safe, you're not gonna leave here when you're not done with this. And then we're like, so I'm in Philadelphia. We'll see Philadelphia because there's gonna be a funeral, right? So that means talking like days and no, I'm talking right here, right now. So let me get my notification. Let me go do the paperwork that I'm talking about because we can go back and forth about what it's like all day long. So I promise we're not gonna leave here for you and you're not gonna take it. Please. I don't even know what to tell you. It's okay. Just take a seat, have some water, give us a few minutes, let us do everything, and we'll be back to talk to you, I promise, okay? Good. Thank you. Thank you.
Yeah. Okay.
You have anyone in there?
Is there my finger just me?
Okay, that's fine. You're right there.
Yeah.
Okay, never mind. I really coming. So same thing.
No further questions.
Thank you. Any cross-examination?
No, sir.
Can this witness be released?
Yes, sure.
Yes.
Thank you, sir. You're released, not subject to recall. Thank you.
Thank you.
State, you may call your next witness.
State would call Melissa Roughgarden.
Yeah, guys, getting him out of there. There's no point in talking to him. So, yeah, it's good they let him go. Move on. Nothing to see.
Yes.
Ma'am, good afternoon. Can you state and spell your name for the record for us?
Melissa Roughgarden, MELISSA
Thank you. Counselor, you may inquire.
Ma'am, who do you work for?
I'm employed with the Orange County Sheriff's Office.
What is your position with the Orange County Sheriff's Office?
Currently, I am a forensic biologist with the forensics unit. Prior to this, I was a crime scene investigator for 5 years.
And how long in total have you been with the Orange County Sheriff's Office?
About 6.5 years.
And tell us all the positions.
I mean, is she a licensed? Is she a sworn officer? I get the feeling she's not because I don't think she I didn't see her carrying a gun. So, like, her wearing that badge, I don't know if that's policy or that's her just way of saying, like, I really am work for the police. I don't know. It just seems weird. Just seems weird to me. Remember, guys, it's all about theatrics at some level, so you wonder why she's doing that.
You've held during that time.
Those two, a crime scene investigator and a forensic biologist.
Let's turn to your work as a crime scene investigator. What does a crime scene investigator do?
We respond to crime scenes. We photograph and document those crime scenes through photographs, notes, and sometimes sketches. We collect evidence, we process the scene, and then we do further processing to that evidence back at our forensics lab.
When you say process evidence or process the scene, can you tell us what that entails?
It depends on the scene and the evidence, but it includes the photographs. We also take swabs for potential DNA. We can also do testing for possible blood and things like that. We also process for latent fingerprints, among other things.
What type of training did you need in order to become a crime scene investigator?
Upon being hired with the sheriff's office, as a CSI, I completed a 16-week training program, which includes in-house processing, as well as going out to crime scenes with trained crime scene investigators to observe and then assist, as well as taking on calls with the crime.
Again, just want to say for the record, this I only get trained in-house is bullshit.
The trained crime scene investigator.
approximately how many crime scenes have you processed in the course of your time as a CSI?
It would be hundreds. I don't know the exact amount.
Were you working in this capacity as a CSI on February 24th, 2020?
Yes, I was.
And tell us, where did you respond out to on that day?
I responded to 4748 Franz Court, apartment 3.
And is that in Orange County, Florida?
Yes, it is.
And when you responded to that scene, whom did you make contact with?
I made contact with the homicide detective, Chelsea Kepsel.
Did you receive information from the detective?
Yes, that it was a death investigation.
Did you walk the scene with the detective?
Yes.
And tell us, what does it mean to walk the scene with a detective in a homicide?
We go into the scene and just observe. We don't interact with anything and discuss what we see.
When you walked this scene, did you see Jorge Torres?
Yes, I did.
Where was he located?
He was located on the floor in the living room of the apartment.
Did you, with the detective, identify potential items of evidence to be collected?
Yes.
You had mentioned previously about documenting scenes with photographs. Was that done in this case?
Yes, it was.
As states M and been shown to defense?
Okay.
Ma'am, I'm showing you what's been marked for identification as states M. Can you take a look at the contents of state M to yourself and tell me if you recognize the items contained within states M?
Yes.
I told you guys that Cleveland's going to lose. You know the feeling. You're a Detroit Lions fan. Like, yeah, but do you like the other Detroit teams? Because if you do, no, you don't know the feeling. Like, that's the thing. The Pistons, the Tigers, the Red Wings. Like, no, you don't know the feeling. If you like other teams that have won championships, you don't know the feeling. I'm just saying. Oh. Yeah, Cleveland smokes rock. Yes, pretty much. I'm just saying. Yes.
You recognize
to be a Cleveland fan requires a special level of, it's a factory of sadness here. The whole city, it's just built up. That's what we do. We mine sadness and despair. And we're connoisseurs at it. So we're a different people. We're a different breed. You think you know us, it's like Bane. It's like, we only know failure. I never heard the word victory. It blinded me. By the time I was a man, I had only known defeat. Oh.
It's the contents of states M.
Yes, I do.
Tell us, what is the contents of state M?
They are photographs I took on the crime scene.
Do they fairly and accurately represent how that crime scene appeared on February 24th, 2020?
Yes, they do.
Here at this time, I'd like to move what's previously been marked for identification, the state's M, into evidence.
How many photographs are there? Do you have a total?
111.
No objection.
Right. What was pre-marked as states M will be received into evidence without objection as states 8.
Funny guy, Sully.
Your Honor, request.
Once again, no, if you're a White Sox fan, generally you're a Chicago sports fan, and you got the Bears, you got the Blackhawks, you got, you know, like it's not, you got the Bulls. I mean, no, it's not the same. It's not the same. It is not the same. Just saying. It's not the same. So, just saying, it's not the same. No.
Permission to publish.
You may.
Your Honor, do we have the lights dimmed?
Yes.
I don't recognize the legitimacy of basketball as a sport. I don't recognize it, so no, it doesn't count.
And I'm first going to publish to you as part of state's M picture photo number 4. Tell us, what is this?
This is
Okay, it's different. People like basketball. I just don't. It doesn't count for me. But a lot of people like basketball. I just don't.
the front door to the residence.
I think basketball's gay, but
State's 5.
This is also the front door of the residence, just a closer image to the door.
this too, very much.
When you enter the residence, what is the first area just off to the right of the front door?
That would be the kitchen.
Showing you it's been marked as state's 11.
Yes, so this is just inside the door. To the right, there is the kitchen area.
Showing you state's 14.
Yes.
What is this a photo of?
So this is the counter with the sink in the kitchen, and there's also the open area just above where you can see into the living room.
Showing you from state's composite, photo 19.
Yes.
What is this?
This is a hutch inside the kitchen. You can see in the background, that is where that first photo of the kitchen was taken. So that's the entryway. And then this is the hutch, and there is a cell phone on the hutch in the kitchen.
Showing you stage 22.
This is the trash can in the kitchen. You can also see the hutch we were just looking at there on the side.
States 23.
This is the contents of the trash can. You can see 2 wine bottles on the top of the trash.
Did you also find receipts in that trash can as well?
Yes.
Photo 25 from the composite.
These are those same wine bottles and 3 Publix receipts that were removed from the trash can.
Did you take these items and collect them into evidence in this case?
Yes, I did.
Photo 32 from the composite.
Yes, this is just in further into that entryway. You can see the living room.
Photo 35 from the composite.
This is another photo of the living room. You can see the victim located on the floor and a suitcase in the bottom corner of the photograph.
Photo 36.
This is another photograph in the living room. This is that wall we saw in the kitchen there with the opening. You can also see a wooden baseball bat leaning against the wall.
Was that baseball bat collected into evidence in this case?
Yes, it was.
Photo 38.
Get in there, chat.
This
Here we
is-
go.
Excuse me. This is also a photograph of the living room, just the other side of the room.
Look, they're so little. They use little people chairs. Aww. It's like they went to Toys R Us to buy their dining room set because they're little munchkins.
Photo 43 from the composite.
Yes. This photograph was taken in the living room. You can see the stairs leading to the second floor.
I'd love to compare these pics, but we don't have them yet. Oh, you mean off the ones I have? Yeah, we're not going there.
Photograph 45.
This is a photograph of the living room just from the other side of the room. You can see the front door in the middle back of the photo.
Photo 49 from the composite.
This is a more close-up photograph of the suitcase.
Photo 50.
This is a photograph of one of the zippers on the suitcase.
Photograph 51.
This is a close-up picture of that same zipper. There is no zipper pull on it. It appeared to be a small wire of some sort, the pink wrapped around the zipper. This is the zipper on the other side of the suitcase.
Just for the record, that's photograph 52. States 53 from this composite.
The close-up image of that same zipper. There is also no zipper pull on that one.
Photo 54 from the composite.
This is the contents of the suitcase after just lifting the lid.
Photo 56 from the composite.
More of a close-up image of the items. There were miscellaneous papers and paperwork, some clothing items, and apparent blood inside the suitcase.
What items, what apparent blood was inside the suitcase?
It was observed on the white cap and a necktie, and there was also visible blood just on the interior of the suitcase.
Photo 57 from the composite.
The contents of the suitcase, but you can see the white cap more clearly and the blood observed on it.
'58 from the composite.
You can see the necktie with blood. It appeared to be silver multicolored. And then there's also a diazepam syringe in the plastic casing there. It was prescribed to the victim.
Wait, he's got a syringe of diazepam? Why does he have it in injectable form? Isn't that a little weird? I mean, yeah, like, why does he have benzos in injection form like that? You think he's got seizures? I know, but wouldn't he just take it, like, when he needed? Like, I mean, like, wouldn't it be pills? I mean, will it work that fast to help him? I guess. But, like, does it work that fast? Like an EpiPen? Like, I'm having a seizure and you just... With the... Oh, it does work that fast? Okay. It works that fast. All right. Yes, it beats Haldol. Well, Haldol's its own. Haldol's some crazy shit, too. Okay. Anyways, here we go. Thank you,
Photo
chat.
61 from the composite.
That is the miscellaneous papers and paperwork that was removed from the suitcase.
Photo 62 from the composite.
That's the suitcase after all of the items were removed.
Photo 64 from the composite.
Yes, that is what appeared to be some like small pieces of paper that appeared to be soaked with blood.
Is this inside of the suitcase?
Yes.
Photo 65 from the composite.
That is the baseball bat that was leaning against the wall in the living room.
Photo 68 from the composite.
This is back to the stairs to the second floor in the living room.
Photo 69 from the composite.
So it's moving closer to the stairs to the second floor.
Photo 70 from the composite.
Photographing more of the staircase. These are the steps leading to the second floor before I proceed up to the second floor.
This is photo 71 for the record.
Whoa, is that blood on the stairs? Oh no, that's not good, Sarah. No, Sarah, that's not good. Oh no, I hope that's just dirty carpet. I hope that's just dirty carpet, chat. Otherwise, Sarah's fucked. Uh-oh. Uh-oh. Uh-oh.
Photo 72 from the composite.
The upper portion of the stairs leading to the second floor.
How many bedrooms were on the second floor of the unit?
There were 2 bedrooms.
Photo 75 from the composite. What is this?
This is the hallway. You can see a closet in the hallway and then the door to one of the bedrooms.
Does this appear to be a child's room?
Yes, it did.
Photo 79 from the composite.
This is a photograph within the child's bedroom.
Photo 86 from the composite.
This is the door leading to the other bedroom upstairs.
Did this other bedroom also contain a bathroom?
Yes, it did.
Photo 90 from the composite.
This is the bed within that bedroom.
Photo 97 from the composite.
This is the bathroom.
In that master bedroom upstairs.
Yes.
Did you also have an occasion to photograph the defendant?
Yes, I did.
You see the defendant here in court today.
Yes, I do.
Could you please point to them and identify our article of clothing they're wearing?
She is right there with a black blazer and a pink shirt.
Your Honor, may the record reflect that the witnesses identified the defendant?
Record so reflect.
Showing you photo 98 from the composite.
This is the photograph I took of the defendant.
Why is it that you are photographing the defendant at this film?
I collected her buccal swabs, which is a DNA standard from the inside of the mouth, and it is part of our procedure to photograph that person for identification purposes.
Do you also document the rest of her body as well at that time?
Yes, I did.
Publishing photograph 101 from State Composite.
This is a photograph of her hands facing upward.
Photograph 102.
This is her right hand facing upward.
Photograph 103.
Her left hand facing upward.
Photograph 104.
Both of her hands facing downward, so the tops of her hands.
Photograph 105.
This is her right hand facing downward.
Photograph 106.
And her left hand facing downward.
Photograph 107.
This would be of her right arm.
Photograph 108.
Her left arm.
Photograph 109.
Her right arm with it facing upward.
Photograph 110.
Her left arm with her arm facing upward.
During the time you were interacting with the defendant, did she ever indicate to you that she had any injuries?
No.
You had previously testified that you also collected physical items of evidence from the home as well, in this case.
Yes, I did.
Your Honor, may I approach the witness who has been marked for identification as state C and been shown to defense?
You may.
Ma'am, I'm assuming it was remarked for identification as state C. Can you take a look at that package for me?
Yes.
Do you recognize that package?
Yes, I do.
And tell us, what is that package?
These are the 2 wine bottles that were collected from the trash can.
Is your name on that package?
Yes, my name is on the Orange County Sheriff's Office evidence label that I filled out, and my initials are on the evidence seal from when I sealed the package.
And it also has your agency case number and the location information for this case.
Yes, that is correct.
Ma'am, could you open the contents of states C and look at it to yourself?
Yes. I have to pull them out to recognize the item they're wrapped in.
Sure, just out of view from before. What is the contents of state C?
These are the 2 wine bottles that I collected from the trash can.
Are these wine bottles in the same or substantially the same condition as they were at the time that you packaged them on February 24th, 2020?
Yes, the same time I collected them that day.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states C into evidence.
Any objections?
No objection.
What was pre-marked as state C will be received into evidence as states 9 without objection.
Your Honor, request permission to publish.
You may do so.
You can unwrap it now.
That's some alcohol. Well, Woodbridge isn't. I mean, the reds for Woodbridge aren't bad, but God, they drink white wine. God, they really are luscious. That's some wino shit right there, guys. Now you're drinking the good Woodbridge wines. Yep, as I suspected, white wine only. Pathetic. Sad. Pathetic.
you also have occasion to collect the baseball bat from the living room?
Yes, I did.
I mean, the other thing though is think about guys trying to take those balls and put them between your butt cheeks. That would be hard. Those are big old bottles.
Your Honor, may I approach the witness who has been previously marked for identification as states B and shown to defense?
You may.
Ma'am, I'm showing you what's been marked for identification as states B. Can you take a look at this item?
Yes.
Do you recognize this item?
Yes, I do. This is the wooden baseball bat I collected from the living room.
Does this item have your name on it?
Yes, it has my name on the Orange County Sheriff's Office evidence label that I filled out, as well as my initials on the evidence seal.
And it also has your initials and your agency case number as well.
Yes, it does.
Ma'am, could you open states B and look at the contents of it to yourself without displaying it to the court?
Yes.
What is contained within stage B?
The wooden baseball bat.
And is that bat in the same or substantially the same condition as it was at the time that you collected it on February 24, 2020?
Yes, it is.
Your Honor, at this time I'd like to move what's previously been marked for identification as stage B into evidence.
Any objection?
No objection.
What was pre-marked as B will be received into evidence as states 10 without objection.
Your Honor, request permission to publish.
You may.
I don't know, Timmy.
You also had an occasion to collect the suitcase as well in this case.
Yes, I did.
Prior to placing the suitcase into evidence, did you process it?
I took measurements of the suitcase.
What are the measurements of the suitcase?
It was 28 inches in length, 20 inches wide, and 8 7/8 inches deep.
Your Honor, at this time, may the witness step down from the stand and approach.
Brad, we're going to get to that in a second, okay? Why she's going through this. This is all to lay foundation. But in the meantime, we do need to come up. We do need to talk about something here. And this is really rather important. There we go. And
the clerk's area.
Yes.
Ma'am, I'm showing you what's been marked for identification as states A. Tell me, do you recognize this item?
Yes, I do.
Tell us, what is this item?
This is the suitcase I collected from the living room.
And how is it that you know that this is a suitcase you collected from the living room?
It has the Orange County Sheriff's Office evidence label that I labeled with the item description. It also contains my name and the agency case number, and my initials are also on the evidence tape.
Ma'am, at this time, could you open States A and look at the contents of it to yourself?
Yes.
No, they didn't bring his body in the court. Brad, we'll answer this question too after we get done with the presentation. Got 20 minutes left, chat.
What is inside of States A?
This is the suitcase I collected from the living room.
And does it appear to be in the same or substantially the same condition as the time that you collected it and placed it into evidence?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as States A into evidence.
Any objections?
No objection.
What was pre-marked as A will be received into evidence without objection as States 11.
And Your Honor, at this time, I'd ask for permission to publish States A to the jury.
You may.
Can you open the inside of it? How easy is it to operate the zipper that closes the suitcase?
It was a little difficult.
I have no additional questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor.
Now, real quick, before we get to anything else, Brad, the reason why we do this, if you're on either side, this is foundational. Remember, we talked about, okay, well, the police responded, and then they found a bunch of things. Okay, well, we have to introduce how this stuff was found. We're also introducing how the chain of custody was kept. And the CSI tech is able to show we did chain of custody. It was found in the apartment by the detective and the cops. I put it in a box. I put my name on it, and now it's here. I'm the people, like, nobody else has had access to it. It's chain of custody. This is the actual item. So they're laying it out that way we can establish it. And now later, when the detective takes a stand, she could say, yep, we found the body right in there. Or the EMTs are going to be like, we found a body stuck inside that thing right there. That's Exhibit A. Yep, that's exactly the one I saw. And they go from there. So that's why you have to lay it out like that. You have to be very explicit when you lay things out. Sarah had to get him out to do CPR, but yeah, didn't she shove him back in or try to shove him back in? Yeah, and and yes, Brad, they're also going to have to, you were asking, are they going to show to prove someone a body could fit in there? Yeah, they will. At some point they will. So, yeah, but right now they're just showing the basic foundation for everything. So, yeah, the body was on the floor, not in the suitcase. Yes, but Sarah said she pulled him out. So if Sarah says she pulled him out, that's proof he was in there, because why would you say that unless it wasn't true? Now, they could try to show a body fitting in there, sure. And they might take his measurements and everything and with the coroner to try to do it. But Sarah admitted his body was in there. Sarah admitted pulling him out, so he's out. He was in there. So, when you watch with Jeff, the body cam showed George laid out in front of the hallway, the entryway. Well, I thought that was by that point, yeah. But anyways, we're gonna get to this, guys. Here we go. Pinata party at Sarah's house.
Good afternoon.
Good afternoon.
Are you also referred to as a medical examiner investigator as opposed to just crime scene investigator?
No, that is not my title.
Do you do reports that the crime or that the medical examiner necessarily relies upon in the process of doing the autopsy and additional investigations?
You would have to ask them.
Who makes a decision at the scene as to what items will be photographed and what items will be taken into custody, what items will necessarily be tested or analyzed?
That's a collaborative effort between the crime scene investigator and the lead detective while on scene.
That would be yourself, and who was the lead detective?
The lead detective was Chelsea Kepsel.
Now, you authored a report in this matter, did you not?
Yes.
And that report was utilized, if you in fact know, by the medical examiner in developing her autopsy report, was it not?
I do not know.
In your report, did you advise the medical or whomever might read your report that in fact the body had been removed from the suitcase by first offenders or first responders?
No, I don't believe so.
And we know that you have the capacity to do DNA analysis, correct?
No, we process DNA or collect swabs for DNA, and then that's submitted to the Florida Department of Law Enforcement for conventional DNA analysis.
You did that with a sample from the inside of Sarah Boone's mouth.
Her buccal swabs were submitted to the FDLE.
And who made that decision?
The detective and I.
Who made the decision not to bother to do a DNA analysis on the blood from the items within the suitcase or the suitcase itself?
That was a discussion between the detective and I.
And chose not to do that?
No, we did not.
You assumed that the blood inside the suitcase belonged to Jorge Torres, correct?
There was blood observed in the suitcase.
But you don't know who that belonged to because you didn't bother to analyze it or have it analyzed, correct?
The blood was not tested.
Now, State's Exhibit B, the bat, you took that into evidence. Was that again a collaborative decision by yourself and the lead detective?
Yes.
And what efforts did you make to have the bat analyzed, given the fact that it was apparently evidence?
It was just collected as evidence from the scene.
Did you advise either the lead detective or anybody else involved with this investigation that there may be matters that could be analyzed when analyzing the bat that would help or assist in the investigation of this matter?
It's my job to do the documentation and the collection of evidence.
Well, you said it was a collaborative effort between yourself and the lead detective, so did you participate in that decision?
We chose to collect the bat and put it into evidence.
And so there was a fiber analysis done on the bat to determine whether or not it was used to strike Jorge Torres when he was in the suitcase, was there not?
Pardon?
In fact, there was not, was it? There was no effort to analyze the bat.
I'm going to object. I don't believe the witness had an opportunity to answer the question.
Sustained. I'm sorry. Please.
Can you repeat the question?
If I can remember it, I will. Do you know that there was any effort made in this particular investigation, the investigation of Sarah Boone, to analyze the bat for fibers?
No, there was not.
And why was that not done?
It was not done.
You indicated that you had some interaction with Ms. Boone, is that correct?
I collected her buccal swabs.
Did you speak with her?
In collecting her buccal swabs, yes.
Did you speak to any other witnesses?
No.
Did you make any determination of other matters that might be of import or evidentiary value when you were going through the house and taking photographs and documenting the interior of the townhouse?
You'll have to be more specific.
Well, how many pictures of the child's bedroom did we see?
Here today,
Yes, ma'am.
we saw the entrance to the bedroom as well as a photograph of the interior of the bedroom.
What was the evidentiary value of that?
It's my job to photograph and document while on scene, so the rooms in the upstairs were photographed and documented.
Did you photograph holes in the wall, possibly made by the victim?
I don't recall photographing holes in the wall, no.
Did you take photographs of items within the house or throughout the house that may have depicted incidents of prior violence?
You'll have to be more specific.
How about bloody pillowcases? Did you make any effort to collect and analyze pillowcases of the rooms that you were photographing?
No.
You have significant experience with zippers,
I use zippers regularly, yes.
enough to have an opinion as to whether or not a zipper is stuck or not.
Is what? Sorry?
You testified on direct that the zipper was a little tight.
Just that it was difficult without the zipper pulls to use the zipper.
And that was your opinion.
Yes, from opening the suitcase here today.
Today, you only tested it today?
Pardon?
You only today have for the first time tested the ability to pull open the zipper on the suitcase?
No, I'm saying it was difficult today.
A redirect examination.
Yes, Your Honor.
That was really good cross. I know some people out there are like, oh, he's being mean. It's like, his job's not to be fucking nice to this lady. I mean, guys, you didn't test it because you didn't think it was important. Notice what her answer was. It was bullshit skipping around. We didn't test it. Like, being nice to her isn't helpful. She's a fucking trained, she's trained on how to be evasive just like a cop is. So, no, there's no walking up there and fluffing pillows and fluffing tampons and playing patty cake. Think about it during the Alec Baldwin trial, guys. With that CSI tech, there ain't no fluffing tampons. It's like, you're fucking going after these people because they do it like cops do. So, no, it's very good cross. Very good cross to this woman.
In this case, you documented the entirety of the house as you saw it.
Yes.
So every room in the house,
They were all taken overall photographs.
walls in the house.
In the overall photographs, yes. They weren't all individually photographed, no.
And you did not document or note any type of holes in the wall or any type of damage to the walls, anything like that.
Not the walls, no.
Is that something that would have been documented both photographically and also within your report?
Yes.
You also, as we've previously seen in the composite, saw the victim where he was laying in this case, correct?
Yes.
Was the victim, did he have blood on his mouth and on his face?
Yes, he did.
Did he have open wounds on his body?
There was blood coming from his nose and his mouth. There was also some other areas, like defects noted on his body.
You also made contact with the defendant too, as well.
Yes.
Did you note any other wounds or cuts or anything else that was not documented that you haven't testified to?
No.
So no wounds, nothing on her.
Not that I recall, no.
No further questions.
And guys, here's the thing. We can agree to disagree. I know some of you guys are like, well, he came across the dick. Yeah, maybe he did. I don't think it was the worst ever. I thought they were trying to get what they needed done, but we could agree to disagree, chat. And obviously, like I said, at the end of the day, it doesn't matter. Sarah's still getting convicted. So,
Thank you. Can this witness be released?
Yes, Your Honor.
Mr. Rollins, can this witness be released?
You can.
Judge, we'd like her to be on call.
Subject to recall, ma'am. Thank you. Can the parties approach?
100%, you could be bleeding from the nose if you're like suffocating. It's a very traumatic event. Although the way it hit the stairs, I'm sure Sarah threw him down the stairs. And also Sarah, when she was smacking the suitcase with a bat, she doesn't know where she's hitting. I mean, she's smacking the shit out of him. I'm sure a lot of that blood is his. I mean, I have no doubt that blood is all his, but they can't prove it. So, yeah, you make the most of what you got. Well, blood, but I can see, but not pillows. Yeah, but they're, we'll see what they're making it up there. Over and under, Sarah cries on the stand. Oh, she's definitely going to cry. She's definitely going to cry. Anyways, looks like we're at the end of the day here, chat. And we'll see.
Much. ID will provide them to you in the deliberation. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer related. at home pictures to see any place discussed during the
But we all know they're going to do it anyway.
trial. Not have by using device for you. All right. Thank you all very much. We will see you at 9 a.m. Monday, October 20th.
Okay, so it looks like they're all done. Sarah's like, "Oh boy, I want to get back to my Pop-Tarts. They're in my locker. They better not eat my Pop-Tarts." I mean, I'll say she's rather smartly dressed. The law students never get to leave. Oh. Chester and fraud. Yeah, whether they put him in the suitcase, she admitted to putting him there. I agree, but at some point, it's still, you just look, they don't have much to go on, so you point out, like, you found blood, you didn't test it. Why wouldn't you test it just to make sure? And it's like, if you're not going to be sure about that, what else did you cut a corner on? So, because remember, they didn't find him in the suitcase. So how exactly do you know beyond, like, do you know 100% that's his blood? Well, no, you don't actually know that. To a reasonable degree, is certainty do you know that? Yeah, but that's not the standard we're using here. So Sarah's like, "Do I have to go now?" And they're like, "Yes, you do." She's like, "I don't want to go." It's like, "Okay, I'll go." I just love how she's all chained up because it's like she'll grab the suitcase and she'll be like, "Nobody move! Nobody move! Anybody who comes at me, I'll pack you. I'll totally pack you." That's great. But that's why I love how she's all like chained up because they're like, it'll be like Homer at the boot. She'll be holding the suitcase with the extended handle. She's like, "I'll extend the handle. Don't make me do it. So help me God." Yes. Oh my God. She's got a duffel bag. Oh, all right. So yeah, guys, that's the end of the first day. Sarah Boone's still screwed. She's still screwed. We got a couple more super chats and other comments we'll read up here. Then we'll answer some more questions if you guys have it. EDW Raptor for $10. Thank you. Is saying, "I turned out a Nelly concert at the local festival to be here with you on a Saturday night. What has my life become?" I'm sorry. You don't get to hear some country grammar tonight. Just Joy has been a member for 5 months. Says, "Sean, can you move chat so people can read the closed captioning?" Yeah, sorry about that. I thought I did it. Sorry. DS says, "Was there a holding tank in the courtroom?" Yeah. But really, where does the jury sit? The arraignment? Well, they sit in the jury box. And DS says, "Is that the woman who got someone in a suitcase?" Yes, this is. Yes. And DS says, "This is for Kate on a new level. Does he have a Baldo?" I don't know, but it sounds like Jorge Torres was like drinking himself to death. And then Maddie B says, "And fighting out of the blue corner. It is a rolly suitcase with an extended handle. Coming in at 3 feet by 2 feet, it is Samsonite." And then Shinohara says, "Who's that Pokemon?" It's Georgeman. Long Hero says that suitcase is too small to hold Nick's stash. Yeah. I don't know if you can fit 20 grand worth of Coke in there. Soul Souffle for $9.99 says, "Thanks, Sean." Well, thank you. I enjoyed it tonight, guys. It was a lot of fun. And we'll work on catching up as we go through the weeks going forward. I don't know which days, like if there are days I'm available, we'll be watching as much as we can, catching up and doing whatever. So, yeah. But thank you. Thank you very much. Although if a soul's getting souffled, like, that sounds kind of rough. So, oh, like a soul getting souffled sounds like it's in hell. Yeah. Hey, Sean, if she didn't film herself, would she be on trial? Probably not. Probably not. Soleil is light and fluffy. Yes, Review Tech USA deleted his channel, yes. Do I stand with center right King Asmongold? No. He goes out the helicopter too. Oh, the Tragos chat does not approve of Sarah gooning. I'm sorry. I'm sorry. That's how people are, man. A lot of I barely put up with it. So it's gonna be rough there. I don't think it's gonna turn out. Like I said, guys, Sarah's toast. Chassaran fraud. Does the defense attorneys ever get into moral issues about defaming a dead person in cases like these? Are they really defaming George? It sounds like he was a drunk asshole that liked to fight women. I mean, it wasn't like the guy was, the fucking Pope. George had his own things, and they're pointing out where he was a shitbag. So, no, I mean, not really. They didn't make him a shitbag. He already was a shitbag. I think George is happy now. He's free from addiction, and Sarah must know we're mocking the shit out of Sarah. Yeah, it could easily be that. Sounds like someone left souffle out in the rain. Maddie, I think the joke is he's dead. I think the joke is that he's dead now. And because he's dead, it's kind of like the jokes about George Floyd being how many, 4 years sober now. It's a joke. George didn't hit women prior to Sarah. Well, got to start somewhere. So, Sarah could be your wife, your daughter, your mother. Oh, very funny. Very funny. Oh. So, yeah, guys, we're all caught up here. Day one's over. Like I said, I think it's only going to get probably more dire for Sarah going forward. I just don't see I just don't see her path to victory. Yes, she could be your girlfriend. Oh. Oh, let's see here. Stabby saying, from what I heard, she was the bully in the relationship, and the cops got called for DV. Someone was going, and they take him because of his intoxication. Maybe. So, Manny says, I heard Sean is voting for Kamala. Oh, yeah, that's it. That's exactly what I'm doing. How'd you figure it out? And I'm actually for the war in Ukraine now. How dare you out me? Oh. Jefferson saying, is death penalty an option since they're in Florida? No, she's not been charged with first-degree murder, and there's no capital specifications on it. No, it's second-degree murder, so no. Nope, she can only go to prison. Only go to prison. Prayers for Jake Cutler. Oh. All right, guys, so we're all set up. tomorrow we are going to do the race. And then I got an idea about something to do afterwards, but we'll see if we'll see how the race goes. So thank you all for being here tonight. I know that most of you are here on YouTube. A couple of you are over on Twitch. Thank you so much for being here, guys. Thank you to all, just chatting along, guys, watching the trial. And then especially those of you who, you said it, super chats, memberships, all that. Thank you so much, guys. I really do appreciate it. And like I said, for those of you that are new, my name's Sean, also known as Potentially Criminal. I am a defense attorney in the Cleveland area. And yeah, this is when there's a trial to cover, we cover the trial. It's a lot of fun. And we plan on doing Sarah Boone pretty much the whole way through. And we will be going through it on a daily basis. And also, just so you guys are aware, we do a weekly show every Thursday night at 9:30. It's a lot of fun. We'll be covering Sarah Boone's recap, but a lot of the other cases that are out there. So if you guys want to join us, Thursday nights at 9:30. And then real quick, guys, our two sponsors, thedragonstreasure.com. Get your teas, your soaps, your coffee there. It's a haven for tea and anime lovers. Use the promo code criminal, get 10% off. And then, yes, MAF Arms at maf-arms.com. 10% off all your wind chime products using the promo code POTCRIM. Clyde was the best part of tonight's stream. Yeah, he usually is. So that's just normally how it goes. Poisonous Paradox says, bye to chat, bye to me, and 2.0, bye, and Clyde. Arrivederci. So Clyde is out there. What time for the race on locals? It starts at 3, so probably around 3 o'clock. Actually, hold on here. What time? Hold on. F1 Austin. What time is Austin? It should be 3 o'clock. Yeah, 3 p.m. So right around 3, guys, we'll get started. That's over on Locals, potentiallycriminal.locals.com. Join us over there. It's a lot of fun, and we'll watch the race together. And yeah, that's it. So good night, everybody. And remember, till next time, just because you did it doesn't mean you're guilty. And here's the thing, Sarah Boone, she's still not guilty for now. But like, we're gonna know. Starting the nosedive now begins, chat. The race to guilty is starting to happen. So, good night, everybody. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy?